So would you please call the roll?
Senator Barrow,
Here.
present. Ms. Brocksmith? Here. Present. Ms. Green? Ms. Guillory? Ms. Haley? Dr. Hook? Ms. Russell? Ms. Sheldon? Ms. Sanji? Mr. Sanji? Ms. St. Germain? Dr. Turber? And Ms. Wascom? Okay.
And Miss Haley is here.
Okay.
And I just received word that Judge Green and Judge Dr. St. Germain are both out ill. So we'll send them a prayer. And it's my understanding that I think that they're watching us. Okay, all right. Well, we hope that y'all feel better. Okay, so today, well, we're going to do things a little different. So instead of hearing from all of our providers and the agencies, we're going to take public testimony first. And so, do I have the cards? So we're going to take public testimony first, and I'm going to ask, I'm sorry here, hold up. So if you're here to provide public testimony, come on up. I'm trying to, do I have the cards? Is it Roger? Okay. I was looking for Major Williams and Dr. Pradette. Yes, yes.
Okay.
And Casey, you want to come up to the table too? You could just sit right there. Okay. All right. So we're going to start with Major Williams and his wife, Dr. Pradette.
Thank you.
Okay.
Good morning.
Good morning.
Okay, so good morning, Senator Barrow and esteemed committee members. Thank you for having us. So we're just following up because we were here a month ago. And Roger and I truly appreciate everything you guys have done for us, very much so, because I know it's not easy sitting up here and listening to all of these topics because they are very sensitive. A month ago we came and spoke on behalf of our now 4-year-old daughter. And I personally find public speaking not my cup of tea. I don't love it, but I found a month ago cathartic, and so we're back again, just following up and updating everybody. So a month ago, we were at the end of our rope. We were exhausted, very frustrated, and just desperate for answers. So we had knocked on every door, spoke to anybody that would answer, and just see who would listen. And time again, we got the same answer of, we're sorry that happened, that's awful, but there's nothing we can do. So we heard countless thoughts and prayers, and it got to the point where I almost detested it. So we had, me and Roger had sat there and talked to ourselves about what our 4 big goals were for the 2 of us to feel okay with what had happened. So obviously, our first goal was to ensure that our daughter was safe and that she had no long-lasting outcomes from what had happened to her. Second was to ensure that the boy who had done stuff to her, that he was safe as well. And then we wanted to enact change to try and see if there was something we could do to change different aspects of the system that we felt had failed our daughter. And then most importantly, we wanted to try anything in our power to make sure that this didn't happen to another family, especially because our daughter's situation was avoidable in our opinion. So we made the conscious decision that instead of letting our anger and our pain consume us, that we were going to turn it into action. And we wanted to make sure that, like, this didn't happen. And, for me specifically, to make sure no husband, like my husband's been tormented essentially for almost a year now, where he discovered his little princess had something terrible happen to her. And the fact that it was easier for him to be overseas taking rockets and missiles and dealing with the fallout of our daughter's sexual assault, it's huge. So anyways, thank you so much. And Roger's going to tell you guys the follow-up of what's happened over the past month with us. Okay?
Thank you. And before you start, Major, I just want to tell you, first of all, your bravery superseded whatever you may have thought about your public speaking. And I want to commend you and your husband for not just staying where you were and accepting what had been said to you, but really motivating yourself to action that is now moved to change. It's going to actually render change. It's going to make sure to some degree that other children, babies who cannot really speak for themselves, do not go through this.
Yeah.
So thank you for doing that.
Yeah, that's the goal. I reached out to an old colleague of mine and mentor. I explained our fight and the shocking reality that the majority of pre-kindergarten programs in Louisiana operate without licensure and outside any real regulation. He listened, and then he told me, Raj, you and Jana are only two people. You need a choir. I asked, well, how does one find a choir? How does one get a choir? And he told me, he said, you need to tell your story. You need to share it. And he suggested that we come before this very committee and share it here. At first, we hesitated. After all the roadblocks and the thought of exposing our family's pain, our secret, in a sense, of being vulnerable in public, it was very overwhelming. But ultimately, Jana and I, we asked ourselves, what else do we have to lose? What do we have to lose? We weren't really getting anywhere. So we threw the Hail Mary. We decided to push through it and come before this very committee. Senator Barrow, when we stood before you last session, we didn't ask for your sympathy. We challenged you and this committee to act. We said we didn't need more of your thoughts and prayers. We needed real change. We needed real accountability. We needed real protections to ensure that no child in Louisiana would be left vulnerable again. And last week, when I received the draft bill from Ms. Trapp, I knew we'd found our choir. Senator Barrow, you and this committee have delivered. Amanda's done a phenomenal job bringing together different departments, untangling decades of bad policy, crafting a clear, common sense bill that will make a real difference. Amanda, your dedication, your coordination, and persistence is nothing short of incredible, and we are deeply, deeply grateful. I also want to recognize the Department of Education for its research and commitment to ensuring meaningful change. While we may not have agreed on everything, I appreciate Ms. Townsend and Mr. Legee for keeping their word and becoming part of the solution. They've met with me multiple times. They've called me throughout the week for input. I also spoke at one of their committee meetings to tell my daughter's story. Again, I'm grateful for their time as well. This bill is simple. It establishes clear safety standards, creates accountability, and addresses the very failures that my family had to navigate the hard way. It's a critical step towards protecting children across Louisiana. But I must express my concern. While this bill is common sense, I know there will be external pressures. Pressures to water it down, pressures to take shortcuts, to put cost over safety, I urge you, Senator Barrow, and every committee member to resist those pressures. Doing what's right is not always the cheapest or the easiest option, and we've learned from experience when you cut costs and you take risk with child safety, what can happen. But the true cost of inaction is far greater. Our children are priceless. Because if we don't get this right, someone else, another mother, another father, someone else's baby, will one day find themselves in our shoes asking the same agonizing question. How was this able to happen? How is this acceptable? We have the opportunity to ensure that this never happens again. Let's not waste it.
And just to add as well, if there is anybody in legislation that doesn't fully support it, you can give them our cell phone number. We will gladly meet with them. We will speak with them. We will travel anywhere in the state, obviously. If it's up in Natchitoches, Shreveport, give them our number. We will sit down with them. We will speak with them. We will tell them our daughter's story because obviously we have a great love for our daughter, and I will do anything for her, obviously, such as this today. So, yeah, let them know if they don't fully support it. Speak with us. We'll meet with them. And that will conclude our testimony today. If you guys have anything, any questions, we really are an open book, and, we appreciate everything, again, so much. It's been very helpful coming here, and we finally feel like we've done something where at least there's positives now, and it's huge. Thank you.
Well, again, I want to thank the both of you, and apologize once again for having to go through this experience. But this experience, if my prayer is that it's going to help safeguard other children, that they will not experience it. And I do believe that your beautiful baby is going to be able to fully recover and walk into the purpose by which God has created her to do, the wonderful work that she will do. It took a lot of courage for you guys to do this, but you're right. This is step one. And we probably, I don't know, I would say we haven't seen how many, got to go through how many committees and then before the floor, probably 6 or 7 more steps, right, before we get to the end. So we cannot celebrate yet. And I will encourage you to follow this bill. Anybody else in the audience or who's listening and interested in the outcome of this bill, to follow it, because we will be filing it. I also would like to say that it's not just me. I spoke with the president of the Senate, and he is all on board. And I think that's half the battle. When you have the president standing behind you, that's half the battle. But he totally understands. He gets this, and we want to make sure that we are removing any roadblocks that would be a barrier to our children's well-being. So, again, I just want to say thank you. I appreciate your courage, and let's get rolling.
Thank
I'm
you.
going to need you
so
guys
much.
down here at the Capitol, down in committee, down testifying before my colleagues.
Thank you.
Anything that we can do to help, Senator Barrow, again, we appreciate everyone's time. We appreciate everyone's hard work, and thank you again for having us.
Okay. And so after we hear our public testimony, we're going to talk about briefly for all the members the legislation that we're working on. I do want to thank the Department of Education for coming on board, working with us to come up and drafting language to really address those gaps so that we no longer have those. So again, after we receive all public testimony, we'll go through the bill. Thank you so very much. Safe travels. And she has a event today, right? What? Mardi Gras parade. All right. That's right. Have fun. Safe travels. Okay. Miss Casey, we have you at the table, and I'm going to ask Mr. Verrett and his wife if they will come on up as well. And we're going to start with you first, Miss Casey.
Good morning. My name is Casey Robry.
Pull the mic a little bit closer to you.
Is that better?
Yes.
I'm here today just to really share my story. I know the first meeting Ombudsman Ritchie talked about several different cases that was of concern to her, and one of those cases was the case involving me and my children. I'm not going to share my children's name just because I will disclose some of the things that they have disclosed because I feel like it's crucial. One thing that we've talked about, in this task force a lot is language, and so I think that's very important that we understand children's language so that we can make changes to better protect our children.
Ms. Casey, before you go any further, let me get clarity from our attorney about how much information we are allowed to disclose. So if you would, Miss Attorney Peck, are you on? Let me see. Okay.
Yes, ma'am. Senator Bauer, I appreciate that she just said she would not disclose her children's name. I would just also say, please don't be too graphic about what your children endured, because with the internet the way it is, it's not hard to trace back your name and who your children are. And this is broadcast live, it is saved. And so while the committee will be happy to accept general conversation just for the protection of your children, please don't be too graphic.
And then because of, are there litigation?
It is,
Okay.
and it's public record what has been disclosed
Okay.
in court. So I mean,
Okay. I
what my
just want to
children
be
have
careful.
Is public record.
Okay, I just want to make sure that we're careful and don't cause any danger to the case. Okay, all right.
And Senator, what we talked about in prior hearings too was this body is here to receive information. We're not a trier of fact, so we also need to be careful about accusing people within the department or government officials by name. I know that's been a problem in the past, but those people are not here to defend themselves, and we're not in a position to have that be broadcast either. So we're different than a tribunal where both sides are presenting their arguments to us. So we certainly can take all of the testimony and be respectful of the families, but just be mindful that that's not our role to make a determination of who was right and who was wrong.
Okay. And I just want to make sure that we have all the safeguards in place to protect the family, to protect our victims, to ensure that we don't jeopardize any of the cases, that people can go back and they can listen to the testimony and use that against you or any individual. So I want to make sure that we are kind of like crossing all our T's and dotting all our I's. But at the same time, I want to make sure that we receive as much information that we can possibly publicly so that we understand the tenets of what's happening, and if there's information that needs to be shared maybe afterwards when it's not live, then we will be I will be open to that, and then I'm sure any other member of the task force would be open to that as well. Okay, I'm sorry.
No. So really my goal is just really to share my story so that we
Okay.
can see the gaps
Okay.
and how the system has kind of failed so that we can really safeguard, our children and make sure that they're protected. I ask that y'all show me grace. I haven't even started and I want to cry.
That's okay.
4 years ago, I left an abusive marriage thinking that I would walk into the family court system and I could just share my concerns for my children and that they would be protected. My ex-husband, even though he had a history of domestic violence, not only with me, but previous relationships and restraining orders, he was given unsupervised visitation with our children. Our children quickly began to display concerning behaviors, started disclosing physical abuse, and within a couple months just started demonstrating things that were very concerning. A couple months in, he had extended period stay with them during the summertime where he was isolated with them in a camper in the woods for 10 consecutive days. And when my children returned, they were never the same. The first concern was when my 2-year-old daughter's diaper was being changed, and she said that her father hurt her and that her father was bad. Out of concern, obviously, I called my oldest child's play therapist, and she advised me to bring her to her pediatrician, which I immediately did. She was examined. They hadn't seen their father in weeks, and so there was no visible evidence of anything that had occurred, but the doctor did inform me that if I ever was concerned, or they disclosed that I needed to bring them immediately to the ER to be examined. She did specify which ER, and within a couple months of that doctor's appointment. So I was just really aware and concerned about behavior weeks following that disclosure. Within 2 months, my oldest child, who was 4 at the time, very clearly made a disclosure and demonstrated things that has happened to her. So I reported it to my local sheriff's office. I was able to get an emergency, I filed emergency ex parte and was granted temporary sole custody of our children. They began an investigation with the sheriff's office, the Child Advocacy Center, and DCFS. Both of my children did complete a forensic interview, and they both disclosed in the forensic interview. We went through court proceedings for that ex parte, and my ex-husband alleged that I'm this crazy, vendettic ex-wife who is just making up false accusations to keep him away from his children. The restraining order in sole custody was dismissed based off of those claims. And after the second unsupervised visitation back with their father, my 2-year-old started complaining about vaginal pain when she returned from her father's house. He did inform me that she was complaining all weekend of vaginal pain. When I attempted to change her pull-up before we went to bed that night, she was hysterical, covering herself, said that her dad hurt her, showed me what her dad did to her in front of another family member. And so I did what the pediatrician advised me to do, was to bring her to the emergency room when she disclosed sexual abuse. So I brought her to that specific emergency room that the pediatrician had advised me to do. They called DCFS and the sheriff's office. They completed a SANE examination. And within 2 days, their father found out about the ER visit, filed an emergency ex parte motion, alleging that I was causing them great harm by the physical examinations that they were enduring because of the disclosures. And while he was under investigation by DCFS and the sheriff's office, I lost all my parental rights of my 2 children for bringing my daughter to the ER.
Hold on for 1 second, Miss Casey. Miss Wascom, I'm just seeing your light. I'm sorry. Was it on before or?
For like interrupting. I wanted to echo something that Ms. Peck was saying, that even the public testimony that everyone, like, that is public knowledge that can be traced. Also, these are minors who can't consent to their details being shared. So I just wanted to be mindful of that ahead of time.
Oh, okay. I'm sorry. I just saw your.
And I apologize.
I didn't know if you had a question for her. Okay. I'm sorry. Miss Casey, sorry. You want to continue?
Yes. So again, I'm out of Lafayette Parish, so Judge Susan Theod of the 15 JDC gave the person who.
So wait, let me stop you right there, because I thought you had a question, but I have a question. So who told you that you bringing your kids to the hospital was causing them more harm?
That was the allegation, and
From who?
From my ex-husband, in the
Okay.
motion to remove my parental rights, custody for my children.
And he was able to do that just based upon that?
Yes, ma'am.
So he had the allegation that you were bringing your kids through more trauma by bringing them to the hospital, and he was able to have them removed just on that?
Yes, ma'am.
Okay.
So even though the judge knew that he was being investigated currently by DCFS and the sheriff's office, and he was refusing to corroborate in the investigation, because of disclosure and that ER visit, I lost all custody of my children, and this was almost 2.5 years ago. So I was put under strict supervised visitation only. The only contact that I have with my children is supervised since then. So after that ex parte motion, we went through a trial over several months where we had lots of people come and testify. We've had lots of people even make reports to DCFS. So the director of the girls' school came and testified, cried while she was on stand, talking about how my children are not the same. There have been issues at school that they have talked about things, have cried when their diapers are being changed, very concerning behaviors. Like I said, I've been under supervised visitation. The supervisor has extensive notes of the sexualized behaviors with my children. I don't know if I should say certain things based off of what y'all tell me. It's not normal for children to act out sexually when they're playing with dolls and Barbie dolls, for them to pretend that they're having sex and that kind of stuff. Clearly, something's very wrong here. They've disclosed to a therapist who has called and made a report with DCFS. I did have an expert witness in my case come and testify, Dr. Viola Von Eden. Just her CV is over 40 pages. She is internationally known with her work for children that have been sexually abused. So like I've stated, my children have disclosed even in a forensic interview. And so one of my concerns is about our knowledge about child's language, right? And so it's very easy for perpetrators to come in, and the built-in defense for someone who's committing these crimes against children is that the mother's making it up, that she's vendettic and she's trying to hurt me by trying to take the children away from me. So a lot of times they allege coaching. And so they say that we coach children that are very young, right? Because children don't speak the way that adults speak. So, for example, one of the ways that something was described was a swishing or a swirling motion in the forensic interview. That's a child's language. If I would have coached my children to make false allegations, I would have said a circular motion is the way that adults talk. So I think that it's very important for us to be able to understand, especially the people that are involved in the processes of these investigations, is to understand the difference between children's language and adult languages. She's also described the pain. The only way that a child, kind of knows pain is like a sharp object or a knife or cutting. And so when we describe things in those ways, again, that's not something that a child would be able to explain unless it's something that they would have experienced. So I had an overwhelming amount of evidence of sexualized behavior, sexualized play, constant disclosures during supervised visitation, hysteria when they would have to go back to their dad, to where they would literally hide underneath the bed and have to be pulled out and held down to go back with him. And even all these experts and the therapists came in and discussed their disclosures, and we watched the forensic interviews. Our judge has kept those orders in place, and they are still in the sole custody of their father. An issue I see is that each agency that has been put in place to protect children has an outsized influence on each other. So all these investigations that are going on, and I know that, each department I hear, is underfunded, understaffed, there's issues, and I acknowledge that. But I do think that a lot of times they say, well, this is a family court issue. There's hearings that's going on. There's been a whole trial. The judge has seen this, and then she's made this determination. So my involvement with different entities like DCFS is that They seem very disinterested. The only time that they want to know anything is when we're going to court and they want to know what that judge has to say in her rulings. So I do feel like they influence each other greatly. Instead of doing a truly independent investigation, they rely on each other and they have an outsized influence.
Okay, I need help. Judge Ritchie, I do not want to put you on the spot, but
She's been involved with my case. I would love for her to come up if she would be willing to.
I need to understand. I don't understand the breakdown. I don't understand. I don't understand how.
And I'm happy to go into more specific detail. There has been numerous investigations with DCFS. I know up until this point, to my knowledge, there's been a minimum of 13 reports made to DCFS. I have made one single one. The other has been supervised visitation, directors of school, teachers, therapists. There's been many, many reports.
I'm still stuck at how you lost your rights by bringing your children to the hospital
I am too.
after being advised to do so. I don't understand
Literally have the
that part.
I have the report from the doctor telling me to do that, which the judge has seen.
So, Judge, I'm not trying to put you on the spot, but because you are a former judge, and since we don't have our judges here, I'm trying to understand how can a determination be made of that magnitude because she's doing what's in the best interest of her child. I don't understand that. Introduce yourself. I'm sorry. We know who you are, though.
Kathleen Stewart Ritchie. I'm currently with the Child Ombudsman's Office with the Legislative
Oh, wait.
Auditor, but I've previously, okay, I'm Kathleen Stewart Ritchie. I'm with the Child Ombudsman's Office at the Legislative Auditor's Office. I have previously served as a juvenile court judge, and I can say that I can't speak to why Judge Thiel made the decision she made. I haven't heard the testimony. I didn't preside over it. And the issue is, in terms of the ombuds work, we don't have any statutory authority to intervene or review any judicial decisions. The remedy, if you're unhappy with a judicial decision, is to appeal. If you are alleging judicial misconduct or some sort of violation of the Code of Judicial Ethics, the remedy is a complaint with the Judiciary Commission, which unfortunately takes years to resolve. And I know that Ms. Robery has appealed several judicial decisions. I don't know what those outcomes are. But what I'm understanding her concern being that she feels that DCFS is not following the same protocols they would ordinarily follow because there's a judicial proceeding that may be an overlay to what they would ordinarily do. In other words, if this matter wasn't in domestic court, would the department's decisions regarding investigation be different? By the same token, DCFS can't override a judge either. So we have this disconnect between what the department's mission is, what their responsibilities are, and how it intersects with what particularly family court custody judges' responsibility and authorities are. And that's one of the issues that the task force is sort of designed to address.
Right.
Because although Ms. Robery's concern is that the civil court proceedings are overriding and having an outsized influence on the department's investigation, I've seen it also be the other way, where the civil court judge just relies on whatever the DCFS determination has been. So there are times when litigants are unable to present the issues that they want to raise regarding abuse of their children because DCFS has either invalidated or said it's inconclusive, and the trial court judge says, well, that's that. There's another issue, I think, in terms of the general admissibility of forensic interviews. Most of the CACs, and now it may be all of them, I know there was a time when Baton Rouge did not videotape forensic interviews so that a child wouldn't have to repeat their story over and over and over again. But those tapes are not generally admissible in a civil court hearing. So that is an issue that this task force can address too. There are times when we wouldn't want those tapes readily accessible, and there are other times when they should be reviewed in camera. One of the complainants with my office, the civil court judge did an in-camera inspection of the CAC tape, and that was all that the judge wanted to see, because that tape convinced her that the alleged abuse was occurring. So, I mean, there are lots of nuances in this process. But I think what I'm hearing Ms. Rovery's concern being that, in addition to the fact that she's concerned about the civil court custody rulings in her individual case, she is seeing that the systems don't coordinate. They're on parallel tracks, and sometimes it appears that DCFS may not be doing what they would otherwise do because of the case being on the custody track. And by the same token, sometimes the civil custody judges do not hear evidence because they believe DCFS has already made a determination that would be dispositive. So it's a disconnect.
Truly. Mr. Barrett, do you mind giving up your seat right quick? I need someone from the department to come. So,
Mr. Powell?
hi, Mr. Secretary. I see you. How you doing? Good, thank you. Good.
Yeah, he's a former juvenile court judge too.
I'm happy to come forward.
You please come forward, yes, because I'm trying to understand that part. I see the level of the disconnect, and I'm trying to see what's the best way to really fix it, because the other problem is it seemed like there's no level of continuity, because I think I heard that in your...
Well, and let me also point out,
presentation.
because both Secretary Matlock and I were on a juvenile court bench, so we never rotated onto a civil custody bench.
Okay.
In the general jurisdiction courts, the juvenile court judge and the custody judge might be the same judge. I'm just exercising two different jurisdictions, or there may be in many of the general jurisdiction courts, there are assigned dockets. So a judge may hear all the juvenile matters, while a different judge in that same court is hearing the custody matters. Our experience is similar in that neither of us ever had those civil custody proceedings before us. I don't think you were ever on the civil bench, huh?
Okay. Mr. Secretary,
Good morning.
wait a minute, you're not on.
Do I-
Okay, there you go.
Does that work?
No, you just cut
Yes.
yourself off.
When it's
Am I on?
red, it's on.
All right. Good morning. Thank you for letting me come forward. I see many friends here. Obviously, I have to be extremely careful about discussing particulars of a particular case, but I think that you would like to know generally this interaction between the civil court
Yes,
custody
yes.
and our child welfare. Our interim assistant secretary of child welfare and medical director is here on this panel, and so perhaps she'll correct any terrible misstatements I make, but they'll still be mine. But I would not want the department to place weight on civil proceedings that are independent of our processes. Our burdens of proof can be different. The evidence that can come in can be different. We can consider things they may not be able to consider. We may not be able to consider possibly some things that they could, but I would not consider typically it's a district court or a family court potentially, their rulings to be tying the hands of DCFS on a child welfare investigation. I wouldn't feel bound by what they determined, and I mean there could be some border areas that I'm not thinking of, but it would be that's separate. Similar criminal, and when somebody's charged with a crime, whether there are certain provisions under the Children's Code that if they're found guilty, those may be able to be that finding of fact or determination beyond a reasonable doubt may be able to come in. But short of that, whether there was an arrest, whether there wasn't an arrest, those are not. I can't speak to how they might influence a particular judge exercising juvenile court jurisdiction, but we don't know what information they had or didn't have at the time. For example, a police officer. Likewise, I don't want them placing undue weight on a so-called finding of valid or invalid or justified or not justified by us. We're limited by the evidence that we were able to pull out, ascertain, bring forward. Witnesses are dynamic. Judge Ritchie knows that as well. And particularly children, they can say something and then they'll remember something else, or forget something. And so we like the independence of those determinations. Now,
So, Mr. Secretary, I'm still struggling with, and so I'm gonna ask the attorney if I ask a question that I maybe should not ask, and I'm not gonna say should not ask, that should not be public, then say maybe I need to state it a different way, or maybe we don't need to have that disclosed publicly.
Ms. Peck can overrule objections.
Yeah, I'm gonna give her that authority to do that because I don't want to jeopardize anybody's case, but because I'm struggling trying to understand when there seem like that there has been so much evidence. Like you have all the different reporters, all these people who are mandatory reporters who have submitted information, and it seems like it's been dismissed. It appears that it's been dismissed. And I know that DCFS cannot overrule the judges. Then that becomes a whole nother. See, the whole judge thing for me is a whole big issue that I'm not understanding really at all.
I would like to just give my opinion just as a mother and someone in the public and not judge. I do think that in family court, it's different from any other judicial branch. In family court, judges are given a great amount of discretion, which is a major issue. Discretion gives them the ability to really act and rule in any way that they want to. You know, when we go to criminal, you have to prove that that crime occurred for someone to be guilty or not guilty, right? In family court, it's often thought of that it's a lot of he said versus she said. So judges are given discretion, which can be very harmful.
Do y'all agree?
All judges have discretion.
Okay.
I mean, particularly in terms of admissibility of evidence, there are rules that judges follow, but, we all bring our own experiences to the bench. And there are some arenas in which discretion is more limited than others. And the civil custody proceedings operate by statutory and jurisprudential guidelines that are different than what the DCFS protocols are. And juvenile court judges have statutory and jurisprudential guidelines that they're to follow too. The if there is a bad judicial decision, and there can be, DCFS doesn't have the authority to override that
Right.
decision, but they're operating in a different arena. So when they make recommendations, what I think sometimes we fail to realize is DCFS doesn't operate in a vacuum. They don't remove the child. They recommend to a juvenile court judge
Right.
that the child needs to be removed from the home for the child's safety. So what you really end up having is two different judicial positions. And that's part of the problem too, is, and it's one of the things that, I'm on the Law Institute, one of the things that we are addressing in the Children's Code Committee is the impact of judicial dispositions, and how long, what the duration should be, and what the extent of the authority that the juvenile court exercises, and how that impacts on the civil court dispositions. The way that the law says that when there is a sync case, that the juvenile court has exclusive original jurisdiction. So in theory, if the department has filed any kind of pleadings, it doesn't even have to be a removal, they can file a safety plan. That preempts any civil proceedings that are ongoing. So for instance, and this happens a lot, I've been amazed, there are two different jurisdictions. So because mom and dad don't live in the same parish anymore, the same judicial district, there was an investigation, for instance, in one parish that resulted in the agency requesting a safety plan. The court had the hearing and issued a safety plan. and then declined further jurisdiction and transferred the matter to the place where the family home had been, the other jurisdiction. But there wasn't a petition filed, so the juvenile judge in that matter transferred it to the civil custody judge. So now we have a safety plan from a juvenile court and the actual factual findings and proceedings going forward in a civil court in a different jurisdiction, and they're operating under different rules and guidelines. So it can be confusing, and it may not result in protection for children.
So let me ask this question. Is this happening across the country in this manner? Are other states functioning in this manner, or is this something unique to Louisiana?
You're asking me?
Yeah, I mean, because
I know that it
is this
has been.
a typical practice of?
This issue of the intersection between juvenile custody and civil custody proceedings has been a topic of discussion in some of the national organizations that I've been engaged with, but I can't really, I don't have the data that you're asking for. I don't know. I cannot imagine that it's not an issue elsewhere, though, because court systems are set up fairly similarly.
Okay, so
So I think we're really looking at 3 issues, right? This is not
Yeah.
a one issue. We're looking at the issues within family court and how they behave and act and make determinations when it comes to child sexual abuse. We're also looking at the systems put in place, that they're having an independent investigation and they're not influenced by anyone and they're following their own policies and procedures, and how they also intersect. So we're looking at 3 separate issues that all work together to make determinations into that fail children like my children.
So, Mr. Secretary, as we are, because I know that there are some limitations on the department in terms of what the department is able to do, I'm trying to figure out how we streamline and make this process better, and so we don't have the judges here, and I don't know if we'll come up with, and I hate to say this, even a resolution before session start, because it's so convoluted and so complex. But this is broken. This is not working. This does not work.
So Senator Barrow, I don't know if you remember last week at the Women's and Children's Senate Committee meeting, my attorney Richard Ducote presented a bill.
Yes.
And I know that Judge Matlock has looked at it and.
So will that kind of help expedite or ease some of that?
Going forward, under the guidance of Dr. Hook and myself, there are processes in place. If there were, the department does not act in a vacuum either. We are bound by judicial directives. Typically, it's a juvenile court or a district court or a city court acting as a juvenile court and we are bound by their determinations ultimately. We gather facts, we present information. I'm talking generally. And
Make recommendations.
and what's that?
Make recommendations.
And make recommendations, file petitions, make motions, and courts hear all the evidence from all sides and make their determinations. And we appeal determinations that we feel like should be appealed. And historical determinations, I mean, any of us could be looked back. You could look back at my record, Judge Ritchie's records, and say, well, but I liked appeals as a judge. I'll just be real honest with you. I liked them. They clarify law, they generalize things, and they make sure that mistakes are fixed. There are time limits for appeals, typically, whether it's an appeal of something done in a civil court, or something done in the juvenile court, if there are new allegations of new instances of abuse or neglect or maltreatment that gives rise to a child in need of care case, then I would hope that those are acted upon. I would hope that we act upon them if they're brought to us or if we become aware of them, and that we would investigate those thoroughly in the context of prior things. You may have X amount of, 9 things of evidence in a case, and then you present that to the court, and the court considers everything and says, not doing anything. But you may get items 10, 11, and 12, and because of the new evidence, you bring that back. And if we bothered to bring it back, I would hope that the court agrees with us, if we're right. And hopefully we'll present the evidence. We would present the evidence effectively. But if we've got items 1 through 9, and there've already been a determination, and we don't have item 10, then there can be legal principles at play that, whether we agree or disagree, can come into play in general cases. So, but I will tell you, Senator, and I can speak for probably 99.9% of the people who work for the Department in Child Welfare, we're here for a reason, and we want to protect children. And we stay awake at night too. We're not as close to it. Maybe we don't know their names. I had this conversation. I was speaking to a group of foster parents yesterday afternoon in Hammond. And a foster parent expressed a concern, and I said, you know their names, you've met them, and I understand. I said, I worry about them, I pray for them, I don't know their names. I said, there are children right now in this state that are being hurt. Ms. Hadley knows. It's why we do this. You don't want a child to suffer.
Absolutely.
Judge Ritchie doesn't. Dr. Hook doesn't. We don't want children being with bad people who are going to hurt them. We don't want to raise other people's children unless we have to. So
But as I listen to Ms. Robery's story, which I've heard more than once, and just kind of you taking because I don't know if we've ever gotten this far. Like,
We're not even halfway through, to be quite honest.
Yes.
But while I appreciate everything that's being said, that has not been my experience. I will tell you, we've had 3 investigations so far. The first investigation, and I understand that there's a lot of different people coming in and out and changes within positions. And some of these people might not even still be here, but some of the caseworkers that I've dealt with when I've made a statement that he was filing ex parte and for sole custody, that first caseworker, when I told her that, literally laughed. And said, there's no way that a judge is going to give him custody. And that's exactly what happened. And when that happened, DCFS wouldn't even speak to me really anymore. And the investigation was quickly closed. The second investigation that began, they told me that the only way that they would find a valid case of child sexual abuse is if, 1, there was an arrest, which has nothing to do with the department, that's a separate entity, and number 2, that they had to do a second forensic interview, even though they had just had one completed. I know that we've talked about that, and they specified the oldest child had to disclose again for them to find a valid case of abuse. So they contacted Hearts of Hope again to ask for a second forensic interview. They refused it, rightfully so, because they had just disclosed. And the words spoken by that case manager by Hearts of Hope said they just provided sufficient evidence for criminal prosecution. So a second one, so they were reaching out to other entities in the state to try to complete a second interview, which they never found. And they closed that investigation. I've had a therapist that made a report to DCFS and still to this day has never spoken to anyone. There are major failures. I've sent in information time and time again, like the expert I was telling you about. She came up with a report. She's actually been hired by the state to train DCFS caseworkers. And every time I bring up her testimony, hand in her transcript, hand in her expert report, I continually ask the caseworkers, have y'all reviewed Dr. Von Eden? Dr. Von Eden, who is that? They don't even know because they're clearly not looking at the evidence that I'm sending in. That should be of great concern.
And not to redirect the group, but I know the Verettes are here. There's another issue altogether when grandparents are trying to go through a civil custody proceeding because of the limited nature of grandparents' rights vis-a-vis parents. So that's another arena to keep in mind when the task force is fashioning remedies to these issues.
So,
But the point is, my children are still in this situation. They're still disclosing things that's very concerning. I know that, Ombudsman has kind of investigated. I've actually met with Mr. Matlock as well. And during the last investigation, that's new information that has come out. They've said that they've spoken to all the supervised visitation workers, which is not correct. I've had one come testify last week to literally my child acting out sexually, making comments,
how old are your kids
complaining.
now?
They're now 4 and 6. It's not normal for a child to constantly complain that her vagina hurts or it itches. That's not normal. The supervisor came and testified a week ago today about all of her concerns and about saying that they were hysterical to leave me to the point that they beg, that it takes multiple people to remove them, that they hold on to furniture. They have been hurt. They've been turned physically violent towards the supervisors to leave begging not to go back to their dads. They've been slapped. They pull their hair.
Who slapped them?
No, my children slapped the supervisors,
Okay.
fighting them not to go back to their father.
The supervisor of visitation.
Yes.
Yeah, okay, not
Who did
not a
they testify
DCFS
to?
supervisor.
To my family court judge. So the supervised center that I have been going to for the last 19 months just closed in December. And so there's no order currently for me to see my children. So I filed a motion. We went before them, same judge, Susan Thiel, and she came and she testified to all this and her great concern for my children, and the judge dismissed.
Where is this? Is this in Lafayette?
15 JDC.
Oh, Ms. Wascom? Hold on, let me get you on. I'm sorry.
Some clear
May I
questions.
excuse for one moment? I just need to walk to the back and walk forward.
Okay, sure.
I'd like to make another statement before your question.
Yeah.
Also, there's other concerns, like one in the order, and again, I've only made one report to DCFS, and that was advised by DCFS to call and make a report. In my court orders that Judge Thiel has ordered is that I cannot make any false reports to authorities. And when I did meet with DCFS back in the summertime, I know that Judge Matlock actually called and made a report himself. And so when the third investigation began this past summer, my ex-husband filed contempt charges against me, alleging that I am continuing to make false reports. Even though I did not make one, we went before the hearing officer, and she did file me in contempt. And she did recommend that I spend 2 days in parish jail.
You have the mic, Ms. Wascom.
Okay. I'm sorry. Okay. I have two questions, one for Judge Ritchie and one for Ms. Robery. One for Ms. Robery first. So after the CAC said that there was sufficient evidence from the forensic interview for criminal charges, were criminal charges filed?
No.
Okay. So the police, is there a criminal investigation? That's what, I just need a clarification on that.
So again, it's my same concern that each department has an oversized influence on each other. When my ex-husband got sole custody, both the DCFS and the sheriff's office quickly closed both cases
Okay.
without properly investigating, in my opinion.
Okay. Okay. And then my question for Judge Ritchie is, you made the comment about DCFS having like the order, like if a child is if they make an order to remove a child from a home, do judges in juvenile or family court, do they have discretion to override that?
Well, the way the law works, DCFS investigates, and if in the course of their investigation, they find sufficient evidence to proceed, there are a number of different ways that they can file pleadings in court.
Okay.
If the investigation results in a concern for the safety and well-being of the child, and the facts required for the child's safety to be removed from the home, they would then contact the juvenile court judge, who can issue an instanter order, either orally or in writing, that removes the child pending a hearing, and the hearing has to occur within 3 days. At the hearing, if the evidence that is submitted, and the parents have an opportunity to present evidence too, if the evidence supports the fact that there are grounds to believe that the child is in need of care and that removal is necessary to safeguard the child's well-being, then the court will continue that child in state custody as the SINC, or child in need of care proceedings, as the process goes forward. DCFS does not remove children unless a judge has ordered the child to be removed.
Okay.
Now, there have been times when DCFS called and asked me to remove a child, and they didn't have the evidence that I felt was sufficient to justify the removal. So yes, that call of removal or not removal, pending a full hearing, that's the judge's call. And there have been times when judges have determined that the recommendation to remove the child was not supported by the evidence that the court was being presented, so denied that. That doesn't mean that the department can't go forward and the district attorney file pleadings in court. You can still do that. It's just the child stays in their own home while those cases are proceeding. The immediate removal, though, has to be predicated on a judicial order. So the court is very involved in this process. But the court doesn't know about this process unless the department or the district attorney's office brings it to the court.
Okay.
Does that make
No,
sense?
I think that answers my question.
Okay.
Thank you so much, Dr. Hook.
Yes, something that Ms. Roby brought up, I think we do need to look at from the task force perspective. This is not the first instance that I've heard where there has been a court order that has stated that a caregiver cannot make a report to DCFS, and I don't know the true appropriateness of that. That worries me that true abuse and neglect is not being reported. I think that is something that we could look to change and make sure that anytime there is a concern, that report can be made. And we also have to keep in mind that just because a report is made, it may not meet the criteria for us to investigate. So if there are concerns, they should be allowable to be reported, and we should not have courts that are mandating who can call into the hotline.
I do agree with that. I do believe that that's used as a scare tactic. I believe that that is why she ordered it, to scare me, to silence me. I mean, I've never been in trouble with the law. I am in a leadership role with my church. I teach Bible study. I was a class mom for both of my children's class before they were removed. I'm a CASA volunteer. No, I've never been in jail, had drug or issues with drinking or nothing. I don't even have a speeding ticket on my record. And the fact that I'm scared to go to jail because someone else filed a report, that's egregious.
I agree. Judge Ritchie, I want to ask,
I'm sorry, we are also the Prison Rape Elimination Act hotline for juvenile institutions, so that was a PREA call.
oh, okay, I'm sorry, is everything?
Yeah.
You need, okay. So, is there, because you said enough evidence, is there a threshold that judges use, because I'm still trying to process that part of it. I get the system breakdown with the department, right? And so there are some things that we need to address. And I just reread the recommendation that you have said, Secretary Matlock, that you agree and that you would be in agreement with in terms of making these changes to law, which will begin to address some of these issues. So we are beginning to make some movement here, but I'm still concerned with because everybody's perspective is different, right? So every judge comes to the bench with a different perspective, but is there a threshold by which they have to lead, govern?
What's the law?
The law, right? The law.
As I appreciated, and correct me if I'm wrong, Article 603 outlines the grounds for child in need of care. And so
Right.
when the department is requesting an instanter order removing a child from the custody of their parents, they have to present facts that rise to the level of reasonable grounds to believe that this child is in need of care. In other words, has been the victim of abuse or neglect, or one of the other grounds. Abuse is defined in the law, neglect is defined in the law, and that the other issue is whether or not the child is at imminent risk of harm if left in the home. So those decisions are made based upon the information and evidence that the department has collected and presented to the court. And one of the issues in terms of, like Ms. Robery's case, I can see how the department might not be recommending an immediate removal because initially these children were safe with her. The issue being investigated was the nature of the visitation with the non-custodial parent.
And I will tell you, not to interrupt you, but that was even said to me by the caseworker. They said, when I had sole custody at the time, we're not really worried about your children, because I was very concerned about the lack of communication, with different parties for them to do an investigation. I kept calling, and they wouldn't respond, and they just weren't investigating very quickly. And she even told me, I'm not concerned. Your children have you to protect you. But when they don't do an investigation and these things happen in family court, how can I protect my children if I don't even have my children anymore?
Well, and so but it's two issues. One is are there grounds to believe that the child has been the victim of abuse or neglect, or that the child is in need of care? Because sometimes neglect can be mom forgot that she had children and left them alone for a couple of days. Well, those children need an immediate removal because there's nobody supervising those children. Mm-hmm. But if it's a situation, so that's the first question, is whether there are grounds. The second question is whether the children are at risk of harm if left in the same circumstances. So there can be situations in which there is evidence that there are reasonable grounds to believe that the child is in need of care, but that second question of whether or not the child should be removed from the home, the answer is no. Those cases can proceed through court. Often they don't because of a lot of reasons. Sometimes the family will cooperate with family services without court intervention, in which case the juvenile judge is not involved. The department works with the family and addresses whatever the deficiency is, and if everybody's cooperating and progress is being made, the court never gets involved. On the other hand, if there is a need to remove a child from a situation that's dangerous, that requires a court's intervention, because only a judge can remove a child from their home. The caseworkers can't. However, I will acknowledge that the parents deal with the caseworker, so they think the caseworker took their children. Right. The judge gets to skate on that. They're not mad at the judge, they're mad at the caseworker.
That's true. Dr. Hook, I still have you on. Did you want to speak more to that? Because I think that is something we certainly need to take a look at.
I will clarify that the caseworker is the one also physically removing the children, and so often that is the face that the parents are seeing or the caregivers are seeing when that removal is occurring. And so I can understand why sometimes our caregivers are a bit frustrated with DCFS in one way or the other. The other thing that I did just want to bring up and this is a it may seem like a small change, but something that we are moving forward with is making sure that our investigation letters for an invalid case very explicitly state that this should not be used as evidence, and that this like invalid or inconclusive finding that we have should not determine any custody matters that are being brought to court as well. And I don't know that that was very clearly stated before, so I think it's very important language that we have in that letter.
That has affected my case, and so I do think that that will make an impact. He has brought that to court, and it's like, oh, you see, they didn't find anything. They investigated. There's nothing. So this is really, that has really harmed me, as well as the language of valid and invalid.
Yes, and we are also changing the language because we're very fortunate to participate in this task force, because there were a lot of things I think that we, doing the work day to day, maybe didn't know or acknowledge were issues. And so if it wasn't for people like Ms. Wascom, we wouldn't even really have thought about changing that language. And so, that is a change that we are going to be making. We have, I think we're settling on substantiated and unsubstantiated, but of course, are willing to talk with the task force and work through that. But the letter, the wording, it's very important, it's powerful, and we need to make sure that it's being used for the appropriate intent and not being used to decide custody.
And we welcome, if I may interrupt briefly, we welcome legislation along those lines as well. So, but we intend to address that, at least in the letter, regardless.
And I do want to also address what Ms. Roby brought up and Dr. Hook echoed. Judges should not be keeping people from making reports that they feel are needed.
That is problematic.
Right, that's not in the law anywhere.
No, it isn't.
That may be something that we need to raise with the Judicial College so that judges can be trained on the fact that that has a chilling effect on people's ability to protect their children. It's certainly not coming from DCFS.
But why? I'm trying to figure out, why would one do that?
To silence someone?
And the other thing that I did want to raise is a potential to address, we may be able to develop a remedy for this, but the situation that Ms. Rovery is in, where DCFS knows that the child is safe because the child's with the mother, but there is another entity, a court, requiring this child to be placed in a place that the department has not yet investigated. The juvenile court doesn't get involved in that, and I just think it's an issue that we need to address. If a child is safe, DCFS should have more time to gather facts.
I would agree.
But if the child's safe on the week but not the weekend, then that kind of defeats the purpose of the way in which they would approach the investigation. If a child's not safe, that investigation has a different priority and a different approach. If a child is safe, then there is a different approach. There's just more time to gather the information. But we have children who are under a civil custody order who are safe part of the time and possibly not safe another part of the time. And I don't know that we accommodate those situations, because as the worker told her, she wasn't worried that the children were going to be hurt because they were with mom. But mom can't keep the children away from the person that's being investigated during the investigation. I've seen that in a couple of cases, and I don't have a suggestion for how to address that.
I have a suggestion, which is the department make good decisions about filing petitions when they need to be filed, regardless of removal. And I would hope we do. I don't mean my answer to imply that we aren't currently, but, and our Deputy General Counsel of Child Welfare, Ms. Sherry Powell, is here, and I know that she, in my mind, are, I think, on one in those regards. A child may be safe, and maybe there's a protective order that'll last 6 months, but if that protective order expires, then 6 months and a day, that child's no longer safe. And if you file a petition, regardless of removal. I mean, leaving a child with a healthy, wholesome, safe parent under protective order, but that doesn't do away, if that protective order expires at a point, the child's no longer protected. If you file a petition and get an adjudication, you have the full 18 years of that child, until that child's an adult, presumably in a better position most of the time to be able to protect themselves. So I like petitions in cases where they don't involve removals. Different judicial perspectives prevail, but the department has a say in whether we file, or ultimately a district attorney
Right, I was
typically
gonna say,
drives
the
that.
district attorney's
But-
office figures in this too.
And they do, and that's another player involved in this, is whether the district attorney determines that. But I don't think that's a particular problem. I think it may be in a particular jurisdiction that I'm not aware of, but I think when the department comes forward with appropriate evidence, our district attorneys are just as interested in protecting families and children as hopefully we are, and I know we are.
But it seemed like it has been in this case.
So what does a mother like me that I'm just trying to keep my children safe do?
Right.
So I go through the family court, and like she said, we can appeal. Do you know how much it costs to appeal? In 2 years, I have spent over $250,000 between attorney fees, legal fees, transcripts. Do you know what it costs just for the transcripts to go to the appellate court? $20,000. How do parents have the money to keep fighting to ensure their children's safety? How do you lose everything trying to keep your 2 young daughters safe?
There are
Most
very
people
few
don't.
families that can afford what
Don't.
it's
No,
just spent.
they
I
can't.
literally have things at the Supreme Court right now. The Supreme Court ruled kind of my favor in one thing tomorrow, so now it's going back to the appellate court. But I have been waiting 2 years to overturn these temporary orders, and my children are not safe. They are not safe. And I have evidence that they're not safe from neutral third parties.
No, I believe you. I'm still struggling. Just
I am as well.
trying to understand procedurally when you have your children, when it's time for them to go back. That alone is always a red flag.
I mean, they've even,
That is a
besides
major red
sexual
flag.
abuse allegations, even they've talked about domestic violence that they've witnessed and said, we're not supposed to talk about that. Dad said we can't, and they cover each other's mouth. There's very concerning things that have occurred, and no one is protecting my children.
Judicially, let me go back to that. So, in this particular, okay, can't talk about, let me see how I want to phrase this. We have the language here that's going to, I think, address maybe some things going forward, not necessarily particularly this case, but for other situations in the future with anyone else. As it relates to steps that needs to be done to look at safety measures for children like these children. Judicially, as a former judge, Mr. Secretary, because I know what we can do as it relates to going to the bar, et cetera, et cetera. But what are some other things that maybe come to mind that may be recommendations?
Working with the Judicial College, collaborating with the Juvenile Judges and Family Judge Association, working with the Children's Cabinet, and working with the district judges insofar as the District Judges Association and the Judicial College with respect to protect orders that might prohibit a reporter's ability to report. That is extraordinary relief. And the department is ready, willing, and able to receive reports of abuse and neglect anytime there is additional information regarding prior neglect. Maybe it's old, relatively old, but we've got new evidence or new information. We want to hear about that through the hotline, and we would prefer a judicial and legislative landscape that would say, okay, don't chill that. Don't prohibit them from reporting that. If they're doing it egregiously, without abusive of the process, then there are other ways of fixing that. You can punish them for having abused it, but don't chill it. Don't do something that's going to prevent good information that the department or law enforcement need in order to do our jobs. And so let the reports be made and then have consequences for that. It's similar to a free speech scenario. And I like to think of myself as a recovering lawyer. So, but typically in free speech, prohibiting speech before it occurs is regarded as a really, really extraordinary remedy. And I wasn't there in any particular cases. I'm not going to go back because I wasn't there. I wasn't hearing the evidence others may have heard in any case along those lines. But in this particular and peculiar scenario where we're talking about calling a hotline, if somebody abuses that, let's remedy that after the fact, and don't try to prohibit folks from being able to report to us. And if I hear things that's new evidence, hopefully I'll act upon it. Others may. This room probably has quite a few mandatory reporters. And if any of us walking down the street, I'm not necessarily a mandatory reporter, but I wouldn't draw a distinction between myself and that. But if we hear things that's new evidence, even if it's of old things, it needs to be brought forward. And certainly if it's new evidence of new things, we need to have those presented to us.
Okay, I hear you loud and clear. That was good.
I'm happy to visit with you after the hearing, Senator.
Yes,
I would
sir.
love to.
Yes, sir. Madam DA, I want to ask you, is there anything that you have heard that you think that because you guys are another component, right, that we may need to look at or evaluate?
No, and I'm listening to the things that we're saying, and you as well, Ms. Robry. We are separate, and our burden is separate. But we work with all of these different entities to make sure on our end we're protecting the children. Are we perfect? No. I mean, we're not perfect. But we certainly, I think, in most of our jurisdictions have a great working relationship with all the entities to make sure that we are protecting the children in the criminal world.
Okay.
One question that I did have for the judge, it's been a long time since I've done civil, you can, yeah.
Me,
you,
okay.
yeah.
Making sure.
It's been a long time since I've done custody cases and family law. Do y'all still use independent custody evaluators when you do that? That looks at all of the agency's reports and evidence?
Are you talking about in a child in need of care case or in a civil custody case?
In a civil custody case, is that
Yeah,
still used?
That's really not my world. I
Okay.
mean,
I can answer that.
what's that?
I can answer that.
I can try to answer it. I'm happy to
just
try, but I would defer to others. But I think many do. And that presents its own issues in those
Right.
cases. I'm going to let others speak to that besides me.
I was just
But
curious to know if there was an independent resource that judges were utilizing to
I often
assist
see
them.
that happen,
Okay.
but I'm a little bit remote from it. I would kind of echo what you said. Our experience with district attorneys around this state is that they're phenomenal. That's been my experience. Certainly up there as a judge in Caddo, but in our working with folks, and I'm sure I can find some one-off situations. I'm sure we could, but I got to tell you, that's not the issue here.
When it comes to sexual abuse and child abuse, I think all of our offices are,
You're amazing.
Yeah.
So that's been my experience.
I do feel
Thank you,
like
Madam DA.
evaluations can cause issues within the family court systems. Thankfully, we don't have guardians ad litem in the state of Louisiana, but often judges will ask for a custody evaluation or evaluation on children. And so if that custody evaluator doesn't have extensive knowledge on domestic violence or child abuse and knows how to identify that, they make recommendations to that judge. And if they don't have experience, they're not making good recommendations, and that's what the judge essentially typically rules on. So that is a great issue that I've seen of other protective mothers around the state. I know that has been something that's come up in my case, and I'm opposed to it just because if there's a custody expert that knows about child sexual abuse that wants to evaluate, I'd be happy to, but I can't tell you of one in the state that has knowledge of child sexual abuse. So
If I could add something that this committee really could work on, in a need of care case, a child welfare case, all of the children have lawyers. In child custody cases, that's rare, somewhere between non-existent and extremely rare for children to have attorneys. That would be huge. Guardian ad litem, we have CASAs, we've got attorneys for the children, court-appointed special advocates. They don't have those things in child custody cases. That's another reason that the law and sort of our general administration of justice says juvenile court child welfare overrides custody typically. The decisions of a juvenile court exercising child in need of care jurisdiction is going to typically override whatever a child custody case may do, but if we can set up some protections in child custody that would allow the courts, and it may have a fiscal note, because when you start appointing attorneys for children in civil custody cases, somebody's got to pay for that. And families it's hard enough as it is to have the resources for that. Guardians ad litem is something that could be looked at, or other things that would give children voice in those proceedings. And I'm not the best person to speak to that, but I'm a person who would speak to, I want children to have voice, whether it's need of care or child custody. And I think that's a big missing component in the child custody cases. Great judges will make sure that they have some voice. But there are time limitations, there are other things, and this group and certainly the legislature could move the needle on giving children voice in those proceedings, and having people there that are looking out, not for mama, not for daddy, not for grandparents. Well, all those are wonderful and need voice too, but someone who's there to speak for those children, because it's an issue, in my opinion. Again, I'm not the best person to speak to that, but there are many who could.
So I do believe that the children should absolutely have a voice. But like he said, who pays for that? And so when we think, I just told y'all how much I spent on child custody. So let's think about this logically, common sense. Family court industry. Family court is literally an industry, a multi-billion-a-year industry that makes great profit. And so my concern is that we add another component for someone that could make a lot of money off of children. So we have attorneys that come in that don't always want to have the best interest of the child at mind because it generates a lot of income for them, correct? If you keep people in constant conflict and children unsafe, you're going to keep them in that cycle to stay in that family court to continue making money, right? Then you add in custody evaluations, you add in reunification therapists. This all generates a great deal of money, including court reporters for transcripts. So I think that we need to be very cautious about adding another player and that could make more money.
I think you bring up a good point, but I think we need to definitely take a look at this. I would like to evaluate it a little bit further. The mere fact that we are really associating the cost and the money making, quote unquote, Because when you said that really, it struck a nerve with me. That some may be actually evaluating or looking at it in that vacuum. That is very troublesome.
Yeah, I will tell you, custody evaluators typically charge each parent a minimum of $5,000 to $10,000. And when you have to constantly, and that also the person who orders it, typically in a situation like this, the parents aren't going to agree. And so the person who makes that determination is the judge. And they typically send them to the same people.
Ms. Hadley?
I just wanted to add into the civil proceedings involving children. I can't speak for all our CCs because we all function differently per jurisdictions. But whenever we receive any kind of subpoena, duces tecums, to provide to civil matters or protective orders, we try to do our due diligence to honor those subpoenas, and we refer it directly to the judge for in-camera inspection with the code of law, making it confidential just to remind them of the law, to keep safeguards for the children. But that's always the concern with civil matters. Like, there's a lot of safeguards for children in criminal proceedings. It's closed off. It's not for public record. But a lot of civil proceedings or protective orders are public record. And if we are asked to provide our information of what was said at our CACs, we are now compromising the child's voice, safety, and confidentiality. And so that's always the biggest concern we have. And we do our best to just bring accountability and reminders to our DA's offices and our judges' offices, but it's also to their discretion what they decide to do in the end. But I just wanted to bring that up just to bring just reminders that we need to safeguard our children, not only in the criminal proceedings, but as well as the civil and protective.
Thank you so much for that.
I will tell you, in my case in particular, they were subpoenaed, but they couldn't testify. They said that they couldn't testify unless it was a criminal matter for that case. We were able to watch the forensic interviews.
And that's understandable because our only interaction with that child and the family, we don't really very much interact with the family as a whole to really give an opinion or what is best, where they should live. Our only interaction is that forensic interview with that child, which could be 45 minutes long, an hour long. And even in that moment, as a forensic interviewer, we cannot say, we know the children inside and out, but we don't. We only have that moment with them. And even in that moment, we're a neutral party. It's not for us to assume one way or another. And we just try to provide that safe space for that child for them to decide to tell us that information. So it is tricky to be asked to testify in civil matters, but we could provide our expertise alone on just the interview piece. But as far as where the child should go, who's going to be best fit, we don't have any of that information to give that opinion. We can just provide our expertise just in that moment of that forensic interview, which is challenging, which we understand.
Thank you so much, Ms. Hadley. There are so many things going through my mind at this point. Some of the stuff I know I cannot say. But what I would like to do, I'm going to ask the staff to help me as we are hearing all the points of concern, because this task force will continue as we are looking to really correct a lot of the gaps in some of the issues that have come up, some of the things that we did not know, right, were concerns initially. We do know now that I want to address them. I am angry, frustrated, but then on the other hand, I'm hopeful that we are able to begin to make this whole process and system better, and certainly at the end of the day, protecting our kids at all cost. When I think about how people may be monetizing the safety of our kids, that angers me. And I do suspect that is happening myself, unfortunately. But we are going to stay the course, and we are going to get to the end where, at least as long as I'm here, that we are going to really be addressing these issues and correcting the problems and saving and safeguarding our children. Ms. Casey, I'm going to ask the Barrettes to come up. You
Could I just
Sure.
make one other statement?
Come on,
So, I was hoping to offer one solution.
Okay, go ahead.
So really, I do feel like the breakdown and what's happened in my children's case started within family court, and the other agencies just didn't investigate. But I think that this happens very often. And so one thing Judge Ritchie said is that, you know, all of these judges were previous attorneys, and they have all their own experience and biases, and sometimes that's the issue that's caused. Sometimes it's just corruption, to be quite honest, or, you know, a relationship with the other party. But sometimes it's really just a lack of knowledge. So a lot of times, well, in Louisiana, before there's any court order, before you see a judge, you go in and you meet with a hearing officer. And that person usually tries to like mediate and come to an agreement with these parties. I'm not specifically talking about child sexual abuse cases, just in general. And so typically healthy parents that are just arguing come to resolution, and they figure out what's best for their children, and they don't go before a judge. And it's estimated that between 76 to 93% of the cases that actually go before a judge is to do with domestic violence or child abuse. And so the majority of what our judges are seeing is on those topics, and they have absolutely no training. So we have realtors that have to go through continuing education every year, or teachers, every professional goes through continuing education, but our judges do not. And so I know that this was one thing that we had talked about last session. We had talked about the Violence Against Women's Act, and you had kind of asked us to condense it down. And so HB 831 was presented by Representative Egan last year. It's a bill on judicial training that mandates 8 hours. And it talks about issues like child abuse, trauma, domestic violence. And a big thing is the behavior and the legal tactics that abusers use. And so I think that it was passed out. I would love this to be reviewed and considered for next session.
So have you spoke with Representative Egan about?
So we voluntarily pulled it because
Okay.
there was some promises that were made to roll out this training this session. We attempted to do a task force, but unfortunately, we haven't received the response that we were hoping for. And so I think it's time now to bring it back and put it into law.
So you guys had received word that they were going to start working on having this done or included, or?
Correct. So we voluntarily pulled it because we thought that we could get it done without passing a law, and that doesn't seem to be the case. So
Okay, I'm going to ask the Sergeant at Arms to pass this out to all the members so that you can have take a look at the proposed legislation. And is Representative Egan considering bringing it back?
we can talk about it again, yes.
Okay, all right. Okay, that's good to know. Thank you. I'm going to ask now for the Barrettes to speak. Typically, when we do these meetings, we kind of do public testimony at the end, but I didn't do that this time because we simply run out of time, and I don't want to run out of time when the issues that are before us are so important from these individuals that we need to hear from. And so I've had the opportunity to meet with them several times, and I would like for you guys to share your story, because as the Judge Ritchie said earlier, grandparents' rights are even further convoluted and hard to even navigate in this process. And so I'm going to ask if you guys would introduce yourself and then feel free to share your story.
Good morning.
Good morning again.
My name's Sharon Verrett.
I'm Quincy Verrett. I'm up here on the behalf of my grandbaby. She's in a not good situation. As of right now, nothing's getting done, to my knowledge. Seem like every time we go to somewhere, it gets shot down. We couldn't make sense of it. We went to do a deposition a couple of days ago. Made my son do a deposition. And in that deposition, we found out some very concerning, that concerns me. Like, very concerning to me. I don't know how y'all gonna feel about it. But we found out the Terrebonne Parish Sheriff's Office never, ever even questioned my son about my grandbaby. Then we found out the attorney, I retained it for my son to represent my son because it had to be in his name, represents Terrebonne Parish Sheriff's Office. That came out of his mouth to my attorney. Not only do he represent the Terrebonne Parish Sheriff's Office, he represents two other entities of the, I don't know how to speak.
The
like
governing
the
bodies of
go-
Terrebonne
The
Parish.
governing body of Terrebonne Parish.
So there's two other entities that we not completely
I know two. I know two.
sure of, but he's the attorney for Terrebonne Parish Sheriff's Office. And, you know, we found out that the investigation was never done on my granddaughter. So the only investigation was done was on his sister. And even though he admitted to showing her the video, they chalked it up as being immature. Found out yesterday she wasn't the only minor that he showed the video to.
So what type of video was this?
It's a video of my son nude and making his private parts move around in the mirror. Well, he lied under oath yesterday saying my daughter didn't see none of this, you know. She was lying. He just told her about what was in the video. Just about everything he said in the deposition, I have to disprove. And it's not somebody's expert. It's not somebody else saying, well, I seen this. These are things that's in his own words. It's photographs he took of my granddaughter. It's drug deals he made with my granddaughter in the car. This is all things that are written out by him, the baby's mama, the new girlfriend. I have a message where he's telling the baby's mama not to be mad at him because I caused this to come out. And the new girlfriend says, well, if she doesn't get therapy, then her mom's not going to be held accountable, bottom line. Well, in the meantime, my granddaughter's cut off from me and my husband. No more contact. So the only contact she has are the people that are hurting her.
And look, he lied a lot in his deposition. So I'm not going to say this is true. I'm going to say this is what was told to us in this deposition. That CPS advised them to get a protective order against us for my grandbaby. Because when we seen my grandbaby at the doctor's office, she was coming out and Kelly was, I'm sorry, the stepmom was holding her I got out the car and I said, hey, honey, Papa misses you. He loves you. They won't let us see you. Now, that is a reason for them to say, supposedly, I don't want to, because it could not be true. It could be wrong. To get a protective order against us. But there ain't no piece of paper. I'm sorry if I offend anybody. Ain't no piece of paper. If I ever see my grandbaby, I'm not telling her I love her.
So,
When was the last time y'all saw her?
May 13th,
of
2
2023.
years ago. We raised that baby for 2 years. We got evidence. They won't get investigated.
And
Won't.
my son had drug dealings in the messages, inappropriate things in the messages, him sharing nude photos of my granddaughter with another woman, telling her he would share her with her. This lady committed adoption fraud where she was going to get her parents to try and adopt a kid because she was
Turned down.
obsessed with getting a little girl. Well, she's got a little girl now, and it's my granddaughter. And
They're getting away with it.
my granddaughter's in Minnesota right now. The exchange was on this past weekend, and my son tried to put everything on me, the things he was doing, which I'm able to prove that it's a lie. And my granddaughter has an attorney that we paid for. Me and my husband paid for her attorney that does zero communications with us. She's gotten zero evidence from us. She only talks to my son's attorney.
Is this the same attorney that you just shared?
Yes.
Okay.
Yes.
You see, the judge ordered an attorney for my grandbaby.
Oh, the judge ordered the attorney?
Yeah, and he ordered us to have to pay for it. But the
Okay,
first,
so the attorney that you guys have is an attorney that was ordered by the judge that you are paying for?
yes, and you see, the first one they appointed, they made him recuse himself, and got this other one of their choice.
And it's not just the sexual abuse, that's the main concern, but there's so much more. Her mom has mental issues. She neglects her other kids. She would neglected my grandbaby. She has a drug problem. My son deals drugs. This is all provable stuff that I'm not making up. He's asking, I have messages where he's asking how much does these, I think it was some type of pain pill were, and he was like, oh, well, that's kind of, expensive. I could get them down south cheaper. So I'm assuming he flew to Minnesota to pick up his stepkids at the time. So he had his fiance's children at the time when he was trying to smuggle drugs back into Louisiana. He couldn't support Gabriella. He still goes from job to job. She's not in a stable situation. There's concerns with the oldest son that I'm not gonna say because he's a minor. His sister she's 17 now, but she doesn't feel safe enough to come forward to talk about the sexual abuse that her brother did to her. She just feels like she's gonna just be made to feel like she's stupid, because that's what she told me whenever she told him about the video. The cop that talked to her made her feel stupid. She doesn't have confidence in talking to a therapist. She was hospitalized because she did tell her therapist she was suicidal. She was tired of waking up in the mornings being afraid that her brother was gonna kill her, since she did come out and say some stuff, because that's what he told her. And my granddaughter's still in this situation. She's going back and forth from two people that were supposed to protect her. And I don't know why, but it seems like when they tell their story, people tend to believe them. When I think I'm probably copied over 5,000 pages of evidence that anybody that wants to look through it, I can let them see what I have. Just like some of the stuff, I don't know her name, but some of the stuff she was saying, it sounded familiar with like that what we were going through with my granddaughter.
Like showing things on
Dials and
At
disclosing
2.5 years
things.
old,
Even
you
after
don't
she
know.
was pulled out of our home, she disclosed things to other people. She said things that a 2-year-old would say, like the dinosaur hurt my poo-poo, to in a forensic interview. And judge ordered her to go to play therapy, which I was paying for. And my son decides just not to bring her anymore. The last therapy session she did have, out of all the toys they had, she chose her parents to be dinosaurs. And when she did her forensic interview, she said that the dinosaurs hurt her poo-poo. So to me, that's saying, she's saying who hurt her, you know? And she could have chose to say, if somebody's making it up, if she's being coached, she could have chose anybody to say hurt her, because she didn't have hardly any contact with her mom. I'm gonna take this drink if you don't mind. She didn't have contact with her mom. I mean, and we were feet apart. And all her mom ever wanted to do was take a nap with her. She wouldn't make sure she was fed. They wouldn't make sure she had diapers. They didn't make sure she had formula. I know they was collecting SNAP benefits for her, and she was living with me. I provided her clothes because they could not provide what she needed. Not even a day my son removed her from our home, he had money to buy her diapers, food. He depended on somebody else to do it for him. And he still goes from job to job. They're gonna move here for a little while, then I think they're gonna try and relocate again. So she's being uprooted again. The only stable home she's ever had was with me and my husband.
She
I
was
made sure
blocked the door, so Papa couldn't even go outside and smoke. She was so attached. And it's almost 2 years I didn't see her.
grabbing when I had to bring her back to her dad, she grabbed a hold to the chair. She begged me not to take her back.
The back house seat, the car, we got pictures with her kicking her little feet prints are still on the seat
So-
because she didn't want to go with them.
They didn't know that I had my Apple Watch on and I was recording. So one of his things he's saying is during the exchange, there's a lot of confrontation. So that's why he's not letting us see my granddaughter, is because there's confrontation during the exchange. Well, I recorded the pickups and drop-offs. And there's no arguing. He was trying to explain why she had a rash on her face and her butt. It's because she wasn't being bathed. She had a staph infection on her face and on her butt. Anytime that if she would sleep with them one night, when she would come back, she would have a rash all over her bottom. And my son told me before that she's been without baths up to 7 days. And I noticed firsthand the mom didn't want to get out of bed to take care of her. She wouldn't play with her. She just wasn't there. And it's the same way with her other children. She just didn't take care of them. I have photos of her son with sores on his body because he would go 6 or 7 days without bathing. Gas being left on because the mom didn't want to get up and feed the children, so they would try and feed themselves, and so gas would be left on the house, and
Like the fire wouldn't light on the stove.
And the house would be
it'd
filling
just
up with
on, just
gas.
filling up with gas.
At one-
3 different times that we know of.
and they did lose their house one time to a house fire. One time my son walked in the house and he said if I wouldn't have went in the camper at the time, Zach would have been dead because the gas was on. The mom left with her and the dog and left the kid in the camper trailer with the gas on. So my son disconnected the gas and said, well, if I'm not here, then it can't be on. So he turned it off where they couldn't turn it on. Him trying to reach out to the other kids' grandparents and family at one point, saying how concerned he was about the other children, but now he's going into court saying he has no concerns. It's just a bunch of lies, and people tend to believe what he's saying instead of taking the evidence I have and looking at it all.
And it's just hard to wrap your mind around. I don't know, like, if it's illegal, legal. I'm not no lawyer. Like, I don't know stuff like this. How can somebody represent? First of all, I paid for him. He's fighting against me. They trying to say we loaned him the money. Who in their right mind is gonna loan someone to hire a lawyer to fight against you? Who in their right mind is gonna do that? He knows we retained him. We had to put him in my son's name. So my grandbaby, we could have tried to stop her from having to go get molested in Minnesota. And then he can turn around and represent him. He can represent Terrebonne Parish Sheriff's Office. He can represent Terrebonne Parish.
Those are conflict of interest.
Well, he's doing it. It came out of his mouth. If you don't believe me, you can ask Mr. Ducote. He was very interested.
I have a problem with the fact that the judge ordered that y'all get an attorney that you are paying for that's also representing that parish.
I didn't understand what you
So-
said.
So the judge ordered that you guys get the attorney that you have, right?
For my granddaughter.
For my
For your
grandbaby,
granddaughter.
he appointed her.
He appointed her, but you guys are paying for her.
He
Right.
ordered us to pay for her 100%.
But
by
that
ourselves.
same attorney
Is
is
representing,
representing,
just her. My son's attorney is
Oh, okay.
representing Terrebonne Parish Sheriff's Office.
your son's attorney
Yes.
that you guys are paid
Yeah.
for,
That we have
That we
paid
had
for.
retained for him and paid till March 7th
Because,
of,
but not your grandbaby. Okay,
yes.
okay.
And,
Thank you, because I think I was about to lose it.
right. So,
Okay.
we retained him
Not much
because
better,
he
though.
needed to file an emergency order to get my grandbaby back from Minnesota. And that was the reason for the retainer. My son had already signed custody over to me.
the mom, they both had actually signed over custody. The judge
'Cause I was
allowed the
raising her.
mama to take her signature back, ever how you call that?
Rescind her signature. But my grandbaby's attorney won't talk to us.
No.
She only talks to the opposing side.
So your son has an attorney.
That we retained.
That we retained, and his attorney also represents
Ter-
Terrebonne
but
Parish Sheriff's
he
Office.
has an attorney for what? Is it because he and the mother are at odds? Why you guys have an attorney for him?
Well, we went to court. It was my wife.
Is that too much information? Okay.
At first, it was my wife. They was giving her custody, signing custody over to her.
Mm-hmm.
They signed custody over. The mom flew to Minnesota. About 3 or 4 days later, she took her signature back. The judge allowed her to do it because it was before he signed the order or whatever, how that goes. Well, we had to go to court because she wanted to bring the baby to Minnesota. And my son was there with my wife and
On my side.
like we was together. We didn't know none of this about my son till we actually took our company phone back from him when he blocked us and took the baby out of our care. This is when we found out the stuff about him was way later. Well, after that hearing and the judge ordered her to go to Minnesota, our attorney told us, look, Matt has to have his own attorney to file like the what kind of order it was?
It was an emergency, I don't remember.
To stop someone from going somewhere. It was emergency.
So initially, this was between he and the baby's mom.
No, her
It
and the
was
baby's mom.
initially between me and the baby's mom because
Okay.
my son had signed his rights over to me.
Okay,
And
gotcha.
she- and
Okay.
she did.
And then me and the baby's mom was in court. Now, at this time, my son was supporting me, and he was, with me getting custody. So he was going to provide me with everything he had against the baby's mama. And it was after that hearing that when the judge had said, well, she's got to go to Minnesota for so many
3 weeks. I
3
think.
weeks, we was like, no way, because she never cared for her before. Like, she didn't know how to cook, she didn't wash her clothes, she didn't do anything. She would take Xanax and Trazodones and whatever else she could take.
Gummies, hallucinating. Like
Stuff
they told,
like
that's
that.
all stuff they told us. Like it's crazy.
And drinking alcohol while taking these things.
But anyway, we're getting off the subject of
Yeah.
how Kentley even got
So,
detained.
yeah.
Right. It's
'Cause-
because now I kind of see. I think I
And then,
misunderstood.
even until we started, when my grandbaby told us her mom touched her and hurt her private, my son was still on board with us. As soon as we tried getting molestation investigated, he started going against us.
Okay. So at this point, though, you guys still are paying for the attorney, though, that's representing him?
Yes.
Okay.
Yes.
All the way until
March
March
7th.
7th was the last time, 2023 was the
Okay.
last time we gave him money. Around that time, he was still saying he was on my side, and we also found out he was voicing his concerns to his attorney about the sexual abuse, which he lies about, says he had no
And-
concerns over it ever, but we found out that he did.
So there are a couple of things that have come to my attention, like just the neglect alone, right? And that should have been enough in terms of with the department to evaluate and take a look at. There's many multiple factors, and I know grandparents still their rights or what rights they may even have is very minimum in these particular cases. In particular, I was going to ask Judge Ritchie a question, just as the ombudsman, as it relates to the process is not because still as mandatory reporters, right? If you see something, you have the responsibility to report it, which you guys have done more than once. And then recently you just heard when you open up the level of conflict of interest and what was told or you guys were under the impression that was done that was never done. So there was never
spoke to him about my grandbaby.
Yeah.
Never.
Never was spoken.
And our attorney kept asking, so Terrebonne Parish Sheriff's Office never ever questioned you about this? No. He did it 2-3 times and then Kentley's like, okay, this is enough. No more asking this question. He answered that already. So he moved on, calm like he always is. And after that meeting, I guess he wanted to fluff his feathers and brag about him representing Terrebonne Parish Sheriff's Office, Terrebonne Parish Coroner's Office, and something else with initials.
And there's multiple
I
things that
don't
he
really
needs to be
remember the
investigated.
initials, so I'm not gonna say. I kind of suspect the initials, but I'm not 100%. I don't really remember.
Like my son needs to be investigated for, he showed his sister that video. And they talked to him about it, but told him, just let him go. But told us, if it would have been my husband,
yeah.
he'd have been in jail.
Now, he's 30-something years old. I'm 52. Why would I get arrested for something that a 30-year-old wouldn't get? That's not. Where's the checks and balances here?
And he touched his sister inappropriately and some other things. They know about him touching her breast, her butt, and they just let him go. And the deputy even told my other daughter that he was probably testing his waters. But at the time, we didn't know that he already had done some things to his sister because she didn't want to tell us.
And
She's not the one that told us. Somebody else did.
you would never believe things about your kid. You come tell me this, what your kid done, like my kid done, I would be like, most parents are going to be on their kids' side. But when you take a phone back from them, because they block you from it, and they don't want to pay their share of the bill or anything like that, because we told him he could have kept the phone, but here is the portion, your portion of the bill if you want to keep it, even though he had us blocked. if this is what you owe every month to keep this phone. He refused to pay it, so we had sheriff's office go get this phone. And then start seeing in his own words what he was doing and saying. You can't deny it. It's him saying it.
Was any of that information shared with authorities?
Yes.
Okay.
Well, some of it. We went, talked to sheriff, the sheriff. He told me and my wife, y'all go home. He said, y'all all over. Go home, make up a timeline. Bring it back to me, I'm gonna look at it. We went home, we made this timeline, we took our time, went through everything we had to make sure we was getting it in order, right dates, everything that they couldn't, say, oh, this ain't worth it, this ain't right, everything right. When we got it all together, he wouldn't even look at it. We didn't know Kentley was their lawyer at the time. We just found this out for this deposition. I don't see how this is even allowed. I don't know. I could be wrong. I don't know.
You're not wrong. I was trying to wait on Judge Ritchie. Oh, Ms. Wascom, I see you have a question. Hold on for a second. Let's see.
Just a quick question. Where is that phone now?
Ma'am,
The phone that
it's
the
at
evidence
my house.
is
We
still-
have it, and we had it authenticated.
Yeah, we had
We
it
had
sent.
it authenticated with forensic. So it went through forensics, and we had it authenticated.
But I just to clarify, law enforcement did not take possession.
No, they brought it back to us. They gave it to my daughter to give back to us because he had his mom's car keys for her Traverse and the phone. So when the cops was there to get the phone, we made him get the keys too. He had took her keys, didn't want to give her car keys back. So that's all we can document. When we got it all documented with police reports, when we got the phone back. So he can't say that, oh, no, y'all did. No, this is when we got the phone back, and that's it. You had it all the other time.
And certain phones, I think iPhone, Samsung, they all have where you can actually see what device took the picture, the location of where the picture was taken, and all this. I have that.
You wouldn't think something like
He's
this
the
can
only
actually
one.
take place.
That in our family that had a Samsung. The rest of us has iPhones.
That's all I have.
Okay. Thank you. Ms. Wascom. He had the phone authenticated. Okay, that's good. I was trying to wait on Judge Ritchie to come back. What I think I'm going to do is I'm going to recess for about maybe 20, 30 minutes. Let everybody just grab something to eat if they like to, and ask you guys to come back. There were some things I wanted to ask Judge Ritchie as it relates to what she can share as it relates to like the whole grandparents situation. I do know that some of the stuff that we have in the proposed legislation would address some of it, but your case is a little different. It's a little different, and where we are right now with the case is certainly concerning, and the information y'all have shared today for me is very concerning. So I think we're gonna take a little recess. Ms. Taylor, I'm gonna ask you to come up just for you and I to talk for a few moments when we recess. And I'm gonna ask everybody to come back. Let me see what time it is. It is 12:25. So I'm gonna ask everybody to come back for 1 o'clock. That'll be a little bit more than 30 minutes. You can grab something to eat right quick, and we will resume at 1. Thank you.
Thank y'all again for giving my
Thank y'all so
grandbaby
much.
a voice.
I appreciate it. Let me kind of give you a little idea of how the rest of the committee hearing is going to go. We are going to hear from, there he is, new state police officer. Really quickly introduce him to the audience, and then we're going to talk about the potential legislation. But before I do that, I want to see if Judge Ritchie would like to say anything, any comments that you would like to make on behalf of the Ombudsman's office. I know that we have talked about some of the things that kind of confine you guys. So would you like to just kind of share that maybe? Or can we look at maybe how we can kind of give you a little bit more flexibility, maybe is the word I'm looking for.
Well, I would just say that we are building the capacity of the office. Ms. Shelton joined me as the Deputy Ombudsman in July, and this week we onboarded an intake coordinator, so we'll be
great.
able to manage the individual concerns that are raised with our office. And I am focused more on the part of the statute that requires the Ombuds office to make recommendations for system reform. I really feel like those recommendations should be data-driven. So we are in the process of building the capacity of this office to meet the requirements outlined in the statute.
Okay.
And I don't think that at this point, I can't think of any statutory revisions that would need to be done that would help us along the line. I'm
Okay.
not certain that won't be the case in the future. But I would like to address something that came up prior to the break, and that is and I don't have a position on this one way or the other, but I do think that it might help the task force members to understand the issue regarding lawyers for children. In juvenile court, the law requires that any child in court for abuse or neglect has an appointed lawyer. Those attorneys are paid with a state general fund dollar that is appropriated every session. There are 3 programs in the state that provide counsel for children. The reason that there are lawyers for children in SYNC cases is that the children are actual parties to the proceeding in a child in need of care case. In a custody case, the child is not a party to the proceeding. That does not mean that the court cannot appoint an attorney to represent the child, but it is not the norm. There are processes where there's some jurisprudential guidelines where the judge can interview the child under certain circumstances if they meet certain criteria. But the norm is not that those children have attorneys. Nationally, there are programs, guardian ad litem programs, where children have.
What is it called again?
Guardian ad litem.
Okay.
And Louisiana does not acknowledge guardian ad litems. It's not in our law anywhere. But we have CASA volunteers. CASA, which is court-appointed special advocates, and it is part of a national organization. Our law requires that the court only appoint a court-appointed special advocate if they are affiliated with a nationally certified program. So we have, at one point, we had every jurisdiction covered. I understand right now that one of those programs is restructuring. But every court, juvenile court, can appoint a court-appointed special advocate. It's discretionary with the court. They have to appoint an attorney. Guardian ad litems in some programs across the country operate in large ways like CASA volunteers. The individual is appointed to represent the best interests of the child. The attorney in the Sink case is required to represent the child's stated interest. So the lawyer would, for instance, we'll say an 11-year-old child who wants to go home, even though all of the evidence points to the fact that that is not in his best interest. The lawyer for that child would have to advocate with the court for the return of the child. The CASA volunteer would provide to the court information and recommendations in the child's best interest and may very well say that child shouldn't go home. So those are two competing objectives. When you have a guardian ad litem program, it is typically just the best interest of the child. So to a certain extent, and the national debate about this is, where do you hear the child's stated interest? In those states that use guardian ad litems instead of attorneys, the attorney does not speak for the child's stated interest, but rather the child's best interest. So there are trade-offs. And their program for juvenile court, where we appoint lawyers, is funded by state general fund dollar. So if the law was changed where the domestic judges had to appoint lawyers in contested custody matters, that would be, the fiscal note on that might be prohibitive. So there are reasons that those two systems operate differently, and lawyers are included in the child in need of care matter and not always in the civil custody matters.
Well, thank you so much for that enlightenment, because that adds a lot of more structure to this whole entire conversation. That helps out a lot. I'm going to look at both, but I see what you're saying.
The National CASA organization is also the National Guardian Ad Litem Association, and I can provide you some information.
Yes, would you
about
please?
how those programs operate in different states and how they are federally mandated in some places. So
Okay.
the Child Abuse Prevention and Treatment Act requires that courts either appoint a lawyer or a guardian ad litem. So Louisiana has chosen to have an attorney represent those children.
Okay. All right. Thank you so much. I appreciate that. My goal is to get everyone out by 3 o'clock today. I'm going to try to stay really close to that time. I really do appreciate, especially this task force commitment and staying in here and being here. So with that said, I am now going to ask Lieutenant Joseph Patou? Patou, okay. To come up. I want to introduce him to this body. Let him introduce himself. And I do want to say some words about Captain Belinda Murphy, whom I've had the opportunity to work with for a couple of years. And we are saddened to see that she retired, but, she was a wonderful woman who was very passionate about this issue. And we had a conversation about her looking at adding another component that she believed that state police was going to be able to do. She was looking forward to working with us on that. And so we look forward to working with you on that. I don't know how much you have been able to hear today and how much we have going on with this particular task force. As you can see, it may be pretty loaded, and we would be leaning on you guys a lot. But I just want to acknowledge her and thank her for her wonderful work and commitment to state police and to the children of this state and to the women of this state, and then wish her well in her retirement. And we want to welcome you aboard and give you an opportunity to introduce yourself.
Appreciate that, ma'am. Thank you. My name is Joe Patou. I'm a state police lieutenant in the Special Investigations Section, currently serving as the executive officer. And appreciate those comments about Captain Murphy. They're all 100% true.
Yes.
And I'm open to any questions that you have.
Okay. I don't think we're going to drill you too hard today. But we will be coming back. This is a task force that I plan to continue in the interim after session. So we will probably start back up maybe in July of August of the of this year. And we will be looking forward to working with you as we did with Captain Murphy on a lot of these issues. And, you have big shoes to fill.
Very good. I'm not the expert that Captain Murphy was. I did spend time as a trooper and as a sergeant in state police as a detective in internet crimes against children. Also hands-on sexual assault cases and with a focus on those things, as a detective response to specialized investigations and sensitive victim investigations. So I hope I can be of help.
Well, we are certain that you will be, and we look forward to working with you. And again, welcome aboard.
Thank you, ma'am.
Thank you. Have a good day. Any questions? Oh, wait a minute. Oh, Dr. Hook.
I was hoping that before you leave today, you might be able to connect with my Deputy Assistant Secretary, Mona Chapman, just to exchange contact information. And we would like to be setting up a meeting in the near future just to discuss some things that we have going on with the Department of Children and Family Services in order to see if we might be able to collaborate and work together a little more closely, if you're willing.
Yes, ma'am.
All right. Thank you so much.
Absolutely.
See, we are off to a great start already. All right. Thank you so much, Lieutenant. Joe, say your last name one more time.
Patu.
Okay, I'm looking at this. Is that P-A-T-O?
UT.
Yep.
Yep.
Okay.
Yes, ma'am.
Patu. All right. Looking forward to it.
Yes, ma'am.
Have a good evening.
That's it?
Yeah, that's it. That's it.
Yes, ma'am. Thank y'all.
Thank you. We do, well, okay. So at this point, I'm going to ask the staff if they would go through the highlights of the proposed legislation that we're looking to do for this upcoming session. And so, will I start with you, Amanda? All right, great.
All right. So the majority of the bill draft that we have put together so far deals with the licensing of the pre-kindergarten programs that are currently unlicensed. So the idea is to bring them all under the authority of Department of Education to give them the ability to monitor what's happening and to make them adhere to certain guidelines. We're also pulling in some minimum safety and welfare guidelines that most of them already exist in the department's rules, but just putting them in statute, just to, codify them and have them there. They really deal with supervision and child-to-staff ratios, just to make sure that those things are being met. We are also working to try to address the issue of who's responsible for responding to certain cases. We've heard a lot of, is it DCFS, is it law enforcement? So we're trying to find some clarity to help parents and reporters know who's responsible for which cases. We're also going to require all schools to report the mandatory reporter completion rates to Department of Education so that they'll have that information and they'll put that on their website so we can start getting a better handle on who's actually getting mandatory reporter training and who's not. We're also looking to add some specific reporting requirements for sexual abuse cases. So we're working with DCFS and law enforcement to figure out how to address the issues when you have child-on-child abuse, to make sure that even if there's no, criminal charges being pressed, that all the children someone's at least looking at them to make sure that they're okay. And then we are going to update the terminology in the children's code with the valid and invalid based on the changes that DCFS and some of the stakeholders have been working on to make those changes in the letters so that that's consistent. And I did want to point out, too, that I know in your folders, everyone has a copy of the evidence changes that was presented by Mr. Ducote. I just wanted to make it clear that that's a separate proposal and that's not incorporated into this draft.
Correct. And he and I have spoken. I don't know if he has an author for that piece of proposed legislation or not, but it's my understanding that there seems to have some agreement in terms of the language and the proposal that's being made as it relates to agreement and moving that forward. So, but I'm not sure who's the author. I wasn't asked to author that one, but this one I am authoring. And if anybody has any questions, we'll take them at this point. Ms. Wascom?
It just has to do with LDOE, the last hearing, and the licensing. I'm just sort of making a statement question, that there's still no, can we put on maybe the next time we meet, start talking about, is there a bill that could be made to have the repository of all of the reports? If there's a report made of an educator, since there seems to not be a, oh my gosh, I'm sorry, I'm blanking. There doesn't seem to be a collection, like no one's
I
responsible
remember.
for that.
Yes.
So just like maybe as like a follow-up for maybe next session, like 2026, where would that look, what would that look like? And then for the pre-K, I had a question. This is not really a question about this, but it kind of goes in with this, is will that include, like, is it just the certified teachers that are going to be followed? Or no?
Oh, hold on, let me see how to do this.
Okay, I think
We all on? Okay, there we go. Yep.
it'll be for the facility.
Okay.
So like for the program.
Gotcha,
Will
okay.
be licensed, not the, so anybody that's providing care to those children
Just
will fall under.
facility, they're all,
Yes.
okay.
Yep.
That's all. Thank you.
Okay, great. Ms. Hadley?
I just wanted to clarify with DCFS and who's making reports to law enforcement or DCFS, is that also along the lines of if, looking into the accountability of if a case is not accepted through DCFS and it's forwarded to law enforcement, the time frame of that, is that also in, looked at as well with what you were mentioning of reports?
Hold on. Let me
There was a
see.
concern on one of the meetings about when only the community will report to DCFS, and for whatever reason, it's not accepted, and it probably just doesn't meet their protocol, but then they forward it to law enforcement to proceed in the criminal side of it. The concern was the timeline of them forwarding that report. And even vice versa with law enforcement, whenever they receive an investigation, what does the policy look like to also make a report to DCFS?
It's not currently in the draft, but this is still a working draft that we're adding to, and that's why Senator Barrow wanted to bring it up today to see what
Yes.
what we're missing, what we want to add. So that's certainly something that
Yes, we need to see how we can maybe add that
incorporate.
to the, yeah, I'm glad you brought that point up. I do remember that as well. Dr. Hook, do I see you coming on? Hold on.
Sorry.
Okay.
I was just going to say that part of our internal process that we're looking at right now too is to try to change the way that our system, I guess, monitors what reports are being referred to law enforcement. And that has not been implemented, but we are working with our data team in order to put those steps in place. Because right now, there is a place where we're able to say, refer to law enforcement. And there is an area where we can document that in our case record. But we're trying to make it more streamlined so that we can make sure that that's done in each case where it should be internally.
So as you guys are working on that internally, what's the timeline? How long y'all think it's going to be before you have it up and operating?
I might have to defer to my Deputy Assistant Secretary for the timeline for those
You want to come
changes.
up? Miss Mona? You thought you had gotten away today. Almost, huh?
Good afternoon, Mona Chapman, Deputy Assistant Secretary with Child Welfare DCFS. So what we have requested is a timeline for being able to implement the changes as a priority for the valid, invalid letters. And so that as a priority has been bumped up to around June if we move forward. So if that stays a priority, it would have to be a little bit after then, so that our systems folks can focus on that. We don't have a specific timeline, though, for that specific request, but we can take it back and get it for you.
Okay, well, yes, I would like to know that, and you guys can send that to, I'm actually to send it to Miss Amanda, and then we can make sure that everybody else receive it as well.
Okay.
And when you guys implement that, what will that require as it relates to all your partners? How will y'all communicate this expectation?
That's one of the things that we're having to look at. So a couple of the things that we're looking at is, one, whenever a report is not accepted because it doesn't meet the definition of a caretaker, those are typically the ones that are referred to law enforcement for our local office to send. And so we're looking at a way to automate those notifications to generate in the system. But each law enforcement, the problem is they require different ways of communicating. One local law enforcement may say, we need you to fax this, we won't accept an email, whereas others will say to email it. So we have to work that out whenever we get to the design session of what that will look like with the system. The other thing that we're doing to try to assist our staff is whenever there's a case that we accept for investigation, it is up to our workers to decide, okay, does this case meet the criteria of needing to refer to law enforcement? Well, what we're going to try to do is hard code some of those, like an allegation of sexual abuse. Well, that should be an automatic referral once we accept it for investigation. So automatically indicate those cases are ones that you need to refer to law enforcement and you need to do it ASAP. So those are some of the changes that we're looking at in trying to streamline it.
Okay, okay. Ms. Hadley?
For those types of cases, do they receive any additional training to understand what would be considered criminal or what would be considered enough to know to make that decision, to report to law enforcement?
Yeah, I mean, that's one of the difficulties with this is because of the amount of turnover we have, the amount of new staff, the amount of knowledge they have to have about
that was
abuse
my
and neglect
concern.
and about the law. And I think that's part of the discussions that we're hoping to have with state police about looking at different options of any assistance they can provide as well.
And to add to that as well, like when it comes to making decisions, even for those non-accepted cases, the vigilance of the information you may have obtained, especially with age development, our younger ones. As a CAC, we would love to provide assistance on child development information or training to DCFS as well to provide from the Gingerbread House in Shreveport area.
I will take you up on that. Yeah, I mean, really, that would be very helpful, even if it's just doing a webinar with all of our staff.
Right.
If you could do that,
We would
that
just love
be
to
amazing.
help them understand the breakdown of whatever information they obtain, looking at family dynamics, environmental dynamics, child development, any disabilities. Those would be considered possible red flags as far as being more prioritized or vigilant to pass that along, probably more so than more of a phone call than a fax. And I know that's not y'all's decision on how it's sent, but I just want to help understand on all sides of that how those can be major factors where we need to immediately connect with law enforcement.
And that there is a concern that we've had with our mandatory reporter portal because it's great. It's an efficient way for mandatory reporters not to have to stay on the line to make the report. However, it takes away that back and forth conversation with the intake worker to get the information that they need to really make a good decision.
Yes, ma'am.
So that's been a challenge for us as well. I did want to take the opportunity too, this is probably a good segue to update on the sexual abuse training for centralized intake, because that's that information gathering, trying to make very good decisions on sexual abuse cases. And I know that Michelle Shelton has been very involved, along with the Advocacy Center out of New Orleans, in developing a training for our centralized intake staff, and that is going to begin on March 10th.
Oh, great.
So, yes, so thank you, Michelle, especially for your help with that. But, and we hope to end that, be completed by April. So that's some good news.
That is good news. And what I would like to encourage you guys to do and to consider is like all the resources that we have here on the DIS and this task force to look at ways that maybe we can have, because this I think would be low budgeted, number one, which is always, I guess a concern to some degree. Yeah, really. But having the webinars is something that you could do. And then I may look into, because I don't know what classes you guys are required to take, and I'm not trying to make things more strenuous on the workers. God bless them and thank God for them, because I know that they are overloaded with the mandates that they are required to do already. But maybe just periodically having them go back through trainings every 6 months or something. A lot of the things that we have discussed during this task force, because sometimes I think people may become desensitized to what they're going through because it's so much for their mental health, right? So I would like to encourage you guys to look at all the resources we have here, along with the Ombudsman's Office, to look at ways of how we can actually bring those individuals together at a time that may be convenient for them. And maybe we can even look at doing like a pre-recorded video that for some people who work at night, right? Some of your workers, where they could have time when it's more convenient for them, because they may not be able to jump on the webinar when it's being done. We can look at another way. We got to make sure we bridge the gap as it relates to information, ensuring that everybody is informed about what to look for, how to look for it, etc. That to me is extremely important, because many of the things that we heard early on was just like a lack of communication or breakdown in terms of how information was disseminated or received.
And what we can do, we have a training platform where we can store trainings, online trainings. And so, if you're agreeable, we can record it and then post it on that Moodle website for all of our staff to review it as needed or when they can, based on their work schedule.
Okay. Dr. Hook.
Yes, I was just going to add about the training that Mona brought up, but it will contain information about normal behaviors for children at different developmental milestones, as well as concerning behaviors. And so we really do want to address that. It is also going to go into some detail about how to collect information that's pertinent, especially to a sexual abuse allegation, because we know that that has been a deficit for our staff in the past. And so can't thank Michelle enough for working with us on that, and then as well as the New Orleans CAC. I mean, they've really been instrumental in providing the content for this training. We expect that our centralized intake team will have completed that training by April, starting on March 10th, but by April we're hoping that everyone will have completed.
Well, that is good news. I don't see anyone else. I did see, was it you, Ms. Shelton, that had your light on?
I just wanted to follow up with the law enforcement referrals I couldn't find in policy, and I know you had brought it up, Ms. Hadley, the making sure it was received by law enforcement. I understand that every agency has a different way, but did you receive this? Is there a police report number that you can put in the file that even if they don't follow through it, they usually will give you a report number to ensure that that occurs, and I didn't see that in policy, but I think that would be helpful.
Hold on for just 1 second. Okay. I think everybody should be on.
Okay. And that is an issue that we are facing right now, because we make those referrals, but then especially if we're faxing or sending something by email, unless we're on the phone and having direct conversation, we will not receive necessarily confirmation that that referral was received or a case number, which makes it extremely difficult for our staff to then be able to follow up on any of the criminal investigation.
And I think we discussed maybe it was state police getting involved in the fusion center that they do with sex trafficking. And that'll be for future discussion, but if they could be kind of, I don't want to, clearinghouse situation of making sure that it gets reported to the right person and is it accepted and that you guys can document those interactions. Because right now I fear something's falling through the cracks in those situations.
I know I think that's our fear as well, and I'm pretty sure it's probably law enforcement's, fear as well, that there's things that are just not getting communicated effectively. And so we really do, that's why I wanted to make that contact today. We had a meeting scheduled with the state police this morning, and due to some unforeseen circumstances, we had to change that meeting time. And so we're really hoping that we'll be able to have conversations. One of the things as DCFS wants to make sure that the state police are going to have the capacity to be able to do that. I do foresee that they're going to need more staffing in order to be able to meet those needs, and there will be funding that's going to be needed for them to be able to, meet all of the needs of tracking these reports and making sure that they're getting to the right place. And so any ask that we make of them, we just want to make sure that they have the full capability to implement.
Well, we look forward to working with Lieutenant Ponto as he help us kind of navigate through those waters. I have no idea what that may look like, but at the end of the day, I know that money is always an issue, but when it comes to the safety of our children, we should be making that a priority. So we look forward to working with him and trying to navigate through that because it troubles me at the fact that, and I know that it is happening, not because someone is desiring that it happens, but it's just happening just because we don't have the safeguards in place. Kids are falling through the crack, and the reports are not being made, and nobody is not following up. That's the truth. It is happening. Ms. Wascom?
Yeah, I just had, my question was for Ms. Chapman, but I hate for her to come back up, but maybe Dr. Hook can answer, are y'all at the mercy of the preference of a law enforcement agency, how they receive the report? So y'all have, y'all don't. I just want to make sure that, so y'all don't have control. You can't say this is how our new policy is going to be. It's purely their preference. Okay, that's all.
Yeah, currently it is their preference, and some of that that factors into that is the ability for them to receive it in certain type of way. If there isn't someone that's able to check like an email inbox in a timely fashion, fax might be the better way for them to receive it. Okay. Some do require that we call it in. And so it really is based on the staff some of the law enforcement agencies are extremely small, and some of the law enforcement officers are even in dual roles. That might not be their primary occupation. And so we have to ensure that they're able to receive the information in the way that we're sending.
Okay, that's all. I just want to make sure that I understood that.
Okay, thank you. Ms. Hadley?
And I also just want to make sure that it's also being received for you guys, for DCFS as well. Because I know we run into the issue when we have law enforcement at an advocacy center, DCFS isn't there yet. And it's, again, not as a pointing the fingers. We just want to make sure that as a CAC, we want everyone at that table. So we want to make sure as well, just reminders or accountability that if there are policies in place on law enforcement side, that they are timely making the reports to DCFS as well. But I also feel like I'm not wanting to add any more to LSP or the state police. I know as a CAC, we're required to sign MOUs where we cover those parishes. And I don't know if that would be an effective way or a moment where that can be more collaboratively clarified in our MOUs that we sign with our multidisciplinary team that we work with, instead of having to be put on one agency to kind of fine line that area. Maybe whenever CACs have to renew or look back at our MOUs, that might be a prime possibility or moment where we can really reflect and come together with all the chiefs of police and the heads of DCFS, where we can make that policy just in the MOUs.
Hold on for 1 second. Let me just add you. I think that's a great point, but
These are just like possibilities. I don't know.
It's a great
if that
point.
works. I don't know.
and I know the trouble we had in trying to do that just with power-based violence, but go ahead.
I love that comment. That's something that Mona has been advocating for a long time now, and we would welcome being involved in that process and really working with all of the CACs, law enforcement, the district attorney's offices, so that we have something that's kind of standardized and we can really.
Right, because I know it's tricky. There's so many jurisdictions and offices that you have to forward those not accepted cases to them. And how can we just better streamline that with all those small entities? And what possibilities? So yeah, just talking.
It definitely is a
dreaming.
problem that we have. We don't even know if law enforcement has an investigation open unless they call the hotline or make a report through the portal. And so there's really no way for us to track that unless either the CAC is contacting us or the law enforcement agency themselves.
Mm-hmm.
Well, I think this is something for us to, think about, think through in the interim, because I think it's something that needs to happen. Communication is key to all of this. And what I'd like to do really quickly, some of you have not said anything. I thought you'd like come on and go off, Ms. Brock Smith, but I'm going to give you an opportunity to make final comments, and I'm going to ask everyone to make final comments because this is us wrapping up this term for the 24-25 legislative interim task force to actually address issues regarding child sexual abuse. And again, I want to thank all of you for participating. But as we wrap up, I'm going to ask that those of you who have not spoken to give final comments. And if you have spoken and you want to make some final comments, just wave a little bit or just turn your light on. And I would like to hear from you as we get ready to end with a product in hand that we are planning to present during this legislative session. So I'm going to start with you, Ms. Brock Smith.
So I did turn my mic on earlier. I was actually going to refer back to Ms. Shelton just about how we handle our cases for the calls that receive for juvenile sex trafficking. So, how we do it since Act 662 was passed. We do take all of those allegations of juvenile sex trafficking, regardless of parental or caretaker culpability. So it could be a non-caretaker, and we do, we actually forward those on directly to state police, and then they refer those on out to local law enforcement. So those have been some discussions on, that being a possibility. And just to give a little quick update about Act 662 and what has really been happening, that we have really seen some great education going out and to our state. It's kind of a double-edged sword. We've seen our numbers go up in reporting, but we're also being able to serve these victims since we are having these cases come in. We've served, I think it was about 836 new victims through the care coordination process, and of course with our advocacy. Our direct advocacy services for our victims, for last year, we served 409 juvenile victims. So we're really seeing a lot of good work with these two services for these kids.
Thank you so much for sharing that information with us and knowing that we are making some progress in that area as well. Honorable Russell, would you like to, I know that you made some comments early on, but would you like to make some final comments?
Yeah, I just want to thank you for putting this task force together and putting us all at the table. While we've seen that we have a lot of work to do, the one thing that I realize is that we're still all with the same common goal. We may be different agencies, but we're all working really hard to try to protect the children in our state. So I think this has been a positive experience, I think, for all of us. I do want to tell you that based upon this and because of this and because of you, we started to have the conversation at the District Attorneys Association about mandated reporting. We're putting together a presentation at our office. We're meeting with our local school board, and every year we're going to start putting on that presentation to them. So this conversation
great.
started because of you and this task force. So we appreciate you, and thank you for all that you've done.
Oh, thank you. That is really encouraging. I'm glad to hear that. That was one of the things that really bothered me when I went home, because I wasn't sure how that was working, and the answers that we received was not comforting. So thank you. I'm glad to hear that. Dr. Hook?
Yes, so I did have a couple updates for the task force. Specifically, I wanted to thank you, Senator Barrow, and then you, Ms. Wascom, for really bringing our attention to some of the areas of our website specifically that need to be improved. We did make some modifications as soon as we left that last task force, and I learned a lot more about our website that I did not know previous to that discussion. What I did learn is Covalent Logic is the company that actually maintains our website for us, and this is separate from our CWIS or our Child Welfare Information System, so they're two separate things. We pay monthly about $400 to Covalent to maintain that website, and then there are things that we have access to that we can change on our own end, and we did make some of those changes. So if you go to our website today, you'll find that we made some changes on the top of our webpage. There is more significance to the report child abuse box that will connect you directly to the mandatory reporter portal or the hotline. It is now red, and then you can click on it and it will take you there. So that's been, I think, a positive change. We have added, or we've actually moved, I guess, to the top of our page, the how can we help you, and there's a drop down tab that will say like report child abuse, so that's more prominent as well. And we've added a child protective services FAQ to the drop down menu so that there are some questions, like frequently asked questions can be easily accessed by anyone that is on our webpage. But the biggest change that we were able to make, and we did have to have Covalent do this for us, is to our search engine. So if you go to our website today and you put in the words sexual abuse, sexual assault, child abuse, and you put it in the search engine, it should bring up within the first two or three of the search options available how to report child abuse or sexual abuse. And that's directly because of you all. So thank you for that.
That is really great news, and I have not had the opportunity to look at it, but I will when we leave here today.
And I looked at it today right before I came just to make sure it was still working.
Okay. Is there anything else that the department wanted to share?
Just that we are working on the language to change invalid and valid to, I think we're going to settle on substantiated and unsubstantiated, that we are working on those letters, especially the what now we would call invalid, but will be unsubstantiated in the future, just to let our survivors have more sensitive wording for some of the letter, because right now it is not. It definitely is not. And again, we have to give Ms. Wascom like all the credit that's due, because we could not have made those changes without her in the task force.
Thank you. Thank you so very much. I greatly appreciate it. I'm going to say my comments to the very last. Ms. Hadley?
I'm just thankful to be a part of the task force. As an individual, it's truly opened up my eyes a lot more to the system, to our partnering agencies. It's just only kind of lit more of a fire to how can we support and collaborate more effectively. And so there's a lot of things that we're trying to take back to our CAC and hopefully get it to LACAC, as far as just refining our trainings, adding more detailed information on our laws with our trainings, as well as how can we better serve our MDT, because our services are free and we can provide our trainings free to our multidisciplinary team, free to the community. And so it's just only sparked more of a fire to do that.
Well, thank you so very much. So encouraging. Ms. Shelton.
I'll just echo what everyone else said. I'm very excited of all the things we've accomplished. It's been a lot of hard work put in here, a lot of input from everybody, and I'm looking forward to moving forward. I think we have a lot to do still, but I'm glad at the progress we've made so far. It's an important task.
Thank you so very much. Dr. Thunberg. Wait a minute.
Well, likewise, it's been illuminating to be a part of this. I think what I have missed has been more information about the interviewing techniques. You mentioned the milestones. I come from the University of Minnesota and the Institute of Child Development, where they've done work on behaviors that indeed differentiate children who have been abused from non-abused children. Controlling for other factors. So I'm wondering about more information in those types of areas. My research deals with suggestibility in children and in memory traces and the interactions between the types of questions asked children and how they retrieve memories in relation to those questions. So I'd like more data on that type of thing. I've also identified about 5 different standardized approaches for interviews. They're not of equal status, but they are extant. And I'm wondering if we are using any of these standardized approaches for interviewing. Does anyone have any information on that?
Hold on for 1 second.
Even have them.
Are you referring to the forensic interviews or just interviews out in the field?
I just call them sexual abuse interviews.
Well, with our forensic interviews, we're required to go through accredited trainings. We go through basic forensic interview trainings, and we're required to continue our education.
Do you know the name of the?
So the one we use is National Children's Advocacy Center. They're located in Huntsville, Alabama.
I'm familiar.
But there's many more. There's APSAC, Radar, Child First. They all are very similar in their techniques and approaches, but also have their differences as well on just certain question types. But majority of Louisiana CACs, we adhere to Radar and NCAC as our basic forensic interview training. But we also continue our education. We learn about age development. We learn, I know a concern was types of wording children use compared to possible words that adults use. We have been trained on what they would say fantastical elements, to not be afraid of those elements being said, because children do communicate in a different way. So we've been educated on that. So as far as for forensic interviews, we are the neutral party involved, but we also collaborate with our MDT that is present for those interviews, and we collaborate on what was observed. And we will educate our MD team, like, just because they said a knife poked them, that's not, or a dragon or a dinosaur poked them. You don't take it for, dinosaurs aren't real. Like, we don't do that. Like, they're being able to articulate in their own way. And so don't be afraid of those statements, and we try to educate in that way. So we're always evolving. This field is evolving, and so we always keep up with all the education.
And there's also an emerging data on children as witnesses in the courtroom. And that's a fascinating area. What kinds of questions are asked by attorneys, to children, childhood witnesses? And that's something I'd perhaps like to
And we
address
provide
another
interviews
time.
for witnesses as well that are like children that have been witnesses to any kind of violent crimes, homicide, or DV. It's not just sexual abuse. If a child's involved, we will provide a forensic interview if they bring them.
Understood. The data suggests that with childhood witnesses, the courts allow more leading questions. Okay? And that's the concern, because a leading question is one where the information is given by the question itself. And
And this is why we hope they come to the judge or a CAC so that they can look at that forensic interview, because we're trained to ask the non-leading, open-ended
you
questions.
are.
So that's why we're hoping that they would use those forensic interviews and not just the statements being said in the courtroom.
yeah, question is what happens in the courtroom. And the
Yeah.
data on got 42 cases in California. Half of them were exoneration, okay, all sexual abuse, okay. Half of them were convictions. And the degree of leading questions of the witnesses was monumental, okay, to begin with. It's also of interest that in those data, these are data from Lyons at the University of Southern California. In those cases, the juries didn't care what the child witness said, okay? They did key on the leading questions that allowed the attorney to kind of create the narrative, okay? So anyway, that is a concern, and we're working with some attorneys in New Orleans in relation to this, because the leading questions just dominated, okay? We're talking about several hundred children here.
Wow.
So anyway.
So, Dr. Thunberg, along those lines, because you brought up I guess I'm not going to say a concern, but I'm just thinking in terms of the interviewing process, in terms of the tool that is used. Is it the same? So, do all CACs use the same one?
So in Louisiana, majority of the CACs have been trained through our NCAC.
Uh-huh.
And there's a few that have been trained in NCAC and radar.
Okay.
So they've been training in both.
So
But majority
it's not necessarily true that they are using the same tool.
I can't speak for all of the CACs, but I know majority of the CACs that I know I've worked with closely use the same protocol
Okay.
that we use in Caddo or in North Louisiana. But that, again, with those trainings, because we use Tom Lyons 10-step as well as part of another type of tool, they're all very similar. The similarities is non-leading questions and open-ended questions. That's the similarity. There's just a few differences that would distinct different type of approaches. But with our continued education, I have been trained under ABSAC trainings, radar. We've been through those, but our main component, at least in Caddo Parish, is NCAC that we use.
That's something I would like to know. Okay. Thank you. Thank you for your comments. Ms. Wascom.
I just want to say thank you again for convening this. And as a survivor, I think it's a good reminder that there are adults in the rooms that are doing the right thing, that really want to do best by our kids. I do want to speak more about the DCFS, that I've very much appreciated having that opportunity to make the language better. And as part of that process, which I can bring in the fall, is I've started contacting the 22 states that use that language, so we can get a more holistic approach, because that is the language that's on their website, but not necessarily maybe that they use in communication. And so I think as the opportunity has presented itself to get a better handle on why we're making this decision, we might as well make sure we have all of the information. And in addition, what I shared with Dr. Hook and the rest of the team that I met with is that DCFS has a lot of joyful stories to share that I think get missed. And so I'm offered to help them a little bit with that, to get an intern and kind of come up with a social media schedule, and also to demystify a lot of these processes. Because I think one thing that has become clear in these conversations is that even sometimes the people that should know don't know who to go to or who to talk to or what happens next or what is this process. And I think demystifying a lot of that might make some of this easier to resolve. But I'm looking forward to it.
When you said that, I thought about maybe a chart that can be placed on the website in terms of outlining the steps.
Yep.
And
I
then
suggested a flow chart.
a flow chart. Yeah, yeah.
I
okay,
love a
see?
flow chart.
Yes.
Yeah.
So yeah, that I think would really help. So, any other comments?
That's all I've got.
Okay. Well, I want to thank each one of you, and I can actually go around and say something about everybody who has participated on the task force, because each of you added such great value, a different perspective, and really helped me to understand procedurally what you do, A, and then B, how it all connects. At the end of the day, I am very result oriented, and so I know that we made a lot of great inroads, and I'm happy about those. But I know I see the work that is still ahead of us, and at the end of the day, I will not rest until I feel like that work has been accomplished. But I do want to thank each of you for being here consistently, participating, responding to our wonderful attorney and staff who have called you repeatedly for various information, and you guys have responded. You have been a part of the process. You've responded. You have given the information, and I just want to say thank you. I want to say thank you to Ms. Amanda personally, Ms. Peck personally, to our secretaries. I see that we have a new one down there who change out from time to time, and to the departments who have come as we have called you. We appreciate you being responsive, coming to the table. Sometimes it was not comfortable, I'm sure, for you guys, but I appreciate you coming, sharing, and willing to work with us. I want to thank all of our constituents who came and shared their stories, because we can't change this situation if we don't know it. And so I appreciate each of you sharing your story, making us aware of where we have fallen short and where we need to make the corrections. So, and my assistant is here, whom bears everything else that nobody sees behind the scene. I want to thank her, as well as my office staff, as we get calls about matters and situations that are happening throughout the state. So with that said, we will finalize the draft. I will make sure that everybody gets a copy of it once we get it pretty much where we think we want it to be, before it's actually filed. You can take a look at it. Please make any recommendations or suggestions to it, and then we will actually file it. Session starts on April 12th, Monday, April 12th. This bill will be pre-filed probably within maybe 2 to 3 weeks, maybe. Yeah, that's the deadline, but pre-filed, yeah, but we can file it before then. Yeah. We're going to file it before then. Everybody can see it once we file it. But that bill will be filed, and I will be working with Mr. Ducote, and I'm not sure who he has lined up to do that other piece of legislation. But be watching out, and I will ask that when we get ready to present it, if you're able to please come, so that you can participate in the process and being able to provide testimony or answer questions that some of my colleagues may have. Okay, I see. Are y'all making comments? Okay. All right, then. So with that said, this actually concludes this particular segment. We're going to put a pin in it. There were a lot of recommendations that were made. I saw Amanda, I saw Ms. Peck write them down. But if there's something else that we need to include, so that as we're preparing the resolution for next term or during the interim of what we're going to look at, please make sure that we have that information so that we can begin to get all of those persons or individuals lined up to make sure that we are bringing all the people to the table that we need to have at the table for addressing other gaps that we have identified. Okay. With that said, that concludes today's meeting. Y'all have a wonderful afternoon. Stay safe, and we will see you when session starts.